If I may.
Yes.
My lord, item number 8, my lord. The conducting council is out of station, my lord. It may be fixed
Transfer
on.
petition.
I'm for the petitioner, my lord.
Transfer
Both the
petition.
petitioners.
Okay.
Item number 8.
8.
Yes, my lord.
You are
Consent-
for the petitioner.
Yes, my lord. Both the petitioners.
Okay. So what about the respondent?
I have sought consent from the other side, my lord.
Okay.
11 or 12 is.
So conducting council is out of station.
Yes, my lord. D River.
Okay, Mr. Patil. Submitted the conducting council, Mr. Dagju Deep Riba is stated to be out of station. Therefore, seek adjournment on his behalf. For how much?
My lord, it may be fixed on 11. 11 or 12, my lord.
Okay.
11 is.
Mhm. Okay. Then he has also obtained consent from the land council of the other side and has prayed for let this list this matter on 11th.
Yes, my lord.
Okay. Then says that praise for listing this matter on 11th. The prayer is allowed. List it accordingly on 11th. Okay.
My lord, item number 9. I'm appearing on behalf of D Tatak, my lord. D Tatak.
Yes.
This matter may be adjourned, my lord, for a week.
So who is for the other side here?
Other side, my lord, service has been completed. However, no one is appearing.
Okay. Whether record was called for here?
Uh,
Okay. It's CRP. Okay. Okay.
my
Mr.
lord, what's up
Patil.
call for in the post?
Here also you have obtained consent from the other side.
No one has appeared. No one has appeared, my lord.
No one appeared.
Yes, my lord.
Okay.
It will
Appearing
list
on
the-
behalf of Mr. David Tata. Praise for adjournment of the matter for the day.
2 weeks.
Of a matter for 2 weeks. Prayer allowed.
There's interim orders, my lord.
List the matter. After 2 weeks, stop. The interim order passed earlier shall continue till the next date of listing.
Much obliged, my lord.
Okay.
May I, Your Lordship? Your Lordship, I beg to mention item number 30.
Item?
30 on behalf of Ketama, Your Lordship.
Just a minute. Huh?
With the consent of the other party, Your Lordship.
Three zero.
Yes, Your Lordship. On behalf of Ketama, Your Lordship.
Mr.
Ketri.
Land Council appearing on behalf of Mr. K. Tama with the consent of the Land Council for the
Petitioner.
respondent. So
Petitioner,
you are for respondent?
petitioner, Your Lordship.
You are for petitioner. Okay, Land Council for the respondent. Praise for adjournment of the matter for
After 3 weeks, Your Lordship.
3 weeks. Prayer law. List this matter after 3 weeks.
Your Lordship, there's an interim order that may be continued.
The interim order passed earlier shall continue till the next date of listing of
Kali Akash.
Yeah, Your Lordship.
Hmm.
Your Lordship, I beg to mention item number 26, 27, and 28. I'm appearing on behalf of M. Kato. The learned
hearing
standing,
matter.
yes, Lordship.
Okay.
The learned standing council is out of station. Therefore, Your Lordship, this matters may be listed after day after tomorrow.
Day after tomorrow.
Yes, Your Lordship.
Day after tomorrow is
5th, Lordship.
Friday, Your Lordship.
5th, Lordship.
Friday.
Yes, Your Lordship.
Friday, Lordship.
The hearing matter Friday, it will be difficult. What about who is for the petitioner?
Sir, we have, Your Lordship, we have obtained consent from the other party.
Okay. No objection.
No, Your
Day after tomorrow, hearing matter would be little difficult. It will be the last date. It's some other day.
Yes, Your Lordship.
Monday, Tuesday, next week. After one week. Okay. Miss
Ojerang.
Land Council. Submitted the conducting council, Mr. M. Kato, is out of station and therefore pray for adjournment, to which Mr. Lord and Learning Council for the petitioner has no objection. Prayer allowed. This is matter after a week. Okay.
Okay, Lordship.
My lord, I think item number 8 has been mentioned, my lord.
Yes.
My lord, in this case, I'm appearing for the FCI respondent, my lord. We need some time for filing our affidavit in opposition.
And then in item 8,
BK Singh.
appearing on behalf of Dr. Riva, sought for
4
adjournment.
and 5.
Mr.
BK Singh for 4, 5 and 6.
VK Singh,
I
Appearing
mean,
on
5 and
behalf
6,
of-
my lord.
the respondent number 5 and 6, also sought for some time to
File our affidavit in opposition.
file affidavit in opposition. In view of the above, let this matter be listed. How much? 11th.
Very short date.
So that, then you have to inform the petition, the person who prayed for, he prayed for 11 and it has been
I will search for him. Otherwise,
after 2 weeks. No, you have to take consent from him again. You have to inform him
let it be
again.
on 11, then we will take further time, my lord.
Okay. Okay.
Oblige, ma'am.
Your Lordship, I beg to mention item number 18. I'm appearing on behalf of N. Paday.
18.
We have taken
18, what this matter is listed for? This other matter, wait for some time, okay? We'll grant you
Item
adjournment.
Number 18, I'm appearing, I'm the petitioner, appearing for the petitioner.
Hmm.
They are supposed to file objection, however, they have not yet filed.
Okay. Now he is busy, okay.
Lordship, item number 5. That this case seems to be completed in lower court. It may be infectious. Lordship, I have to talk with my client, Lordship.
Hmm?
Lordship, item number 5. This may be taken after
After?
2 weeks, Lordship.
My lord, I am for the respondent number 2.
You have correspondent number 2.
Yes.
You have for?
For the petitioner, Lordship.
You wait to file
I'm for
your votes, okay. Reply, you wait to file
Lordship,
affidavit in reply,
yes, Lordship,
yes.
reply already filed, Lordship.
already filed,
Yes.
Yes.
affidavit in reply also?
Yes.
Okay, now you want this matter to be listed?
Lordship, this seems to be that infectious now that I
Okay.
have to consult with my client, Lordship.
Okay,
So, give me a moment.
Mr. G. Kato.
One time will be given so that I
Okay,
can.
Learning Council for the petitioner submits that the matter appears to have become infructuous. However, we seek for some time to obtain instruction in this regard from his client and prays for some time. Prayer allowed. List this matter after
And Lordship, after 2 weeks, Lordship.
2 weeks. Ms. G. Taro for the state and Ms. J. Doji for the respondent number 2 are also present. Okay.
Okay.
Obliged, Lordship.
my place, Lordship.
Lordship, item number 11. I was supposed to wait the term, but since it is in admission hearing, item 11 and 24, they are the connected matter, Lord.
So what do we do? What is the submission?
Lordship, here the service report. Item number 11 is in admission, but item number 24, both connected matters. 24 is in orders.
Okay, Mr. Kalon, Learning Council for the 11, huh? For the petitioner is present. The service upon the respondent is
11 and 24.
Respondent number 2.
service upon the respondent number 2 is still awaited. In view of the above, let this matter be listed after
3 weeks.
3 weeks. 11 and
11 and
24.
Both
24.
Plus together, Lord.
24 also similar order. Okay.
Obliged.
There is an interim order, Lord.
The interim order pass earlier shall continue till the next date of listing. Okay. 11 and 24, huh?
Yes.
Okay.
Lordship, one would maybe then both club matter may be club together, Lordship. Otherwise, on next day, what may be
Okay.
separate.
Okay, then in 11 says, in view of the above, let this matter be listed after 2 weeks along with the analogous matter, criminal petition number 3, 2016. No, not
Lordship,
3.
179
179, 2025. It's item 24. Okay.
Yes, Lord. Deeply obliged.
Item number 1.
May it please your lordship.
Yeah.
Lordship, the matter was supposed to be listed on admission today, lordship. But however, it has been, last week the motion has already been done. And the direction was given to the learned additional PP to obtain the instruction from the Nirjuli PS.
Yes. Why it has been listed for motion? So, have you obtained instruction?
Yes, Lordship. Lordship, actually,
What is the instruction?
it has already been submitted as a final report, Lordship.
Final report?
Yes, Lordship.
Let me see.
Lordship, today is the 85 days. So
So then
85
it
days?
makes-
85 days of,
This is criminal petition?
yes, lordship.
Then, if final report submitted, it's become infructuous, Lordship.
So, this has already been submitted in the final report.
Yes, Lordship.
It's not a charge sheet.
No, Lordship. After investigation, there is nothing found and it has been.
Then, so nothing remain.
Yes, Lordship.
Final report already submitted. No case against you. It has become infructuous.
Yes, lordship.
So, okay. Mr. S. Direct counsel for the petitioner. Stop. Ms. L. Javier, Direct additional public prosecutor for the state. Submits. On instruction submits that the usually submits that she has an instruction that the Nirjuli PS case number 81/2025 you earlier submit that it was the matter is pending before the judicial magistrate first class.
Yes, lordship, we had again withdrawn it with the liberty to file fresh. Again, this is the second attempt.
And in the second, you submit that the case is pending before the JMFC. Listing anything.
No, Lordship. Only FIR, they have watching for FIR, Lordship.
No. So there was a production of the accused before the court. That is
Yes,
why.
lordship.
Oh, yeah, Lordship.
Okay. So that is why it has been numbered. But in fact, the matter is not pending before the, it was not yet pending before the magistrate court. But now it has been submitted in the final report. Registered against the accused under section 78(2) of BNS read with section 66(e)(2) of Information Technology Act 2000 on completion of investigation, having not found any material against the accused, has been submitted into final report. Staff, in view of the above, the matter has become infructuous. Staff. Accordingly, this has prayed for, this criminal petition is disposed of on becoming infractions. Okay.
Highly obviously.
Ablaye
Item number two.
May it pleases your lordship.
Yes.
My lord, am I audible, my lord?
Yes.
My lord, this is a quashing petition. My lord, this is a classic case of abuse of the process of law. My lord, may kindly come to page number 1414. Here is a case where the allegation simpliciter is that the accused have taken a loan of rupees 55,000 and he has not returned it. Now, my lord, can this be an case to be registered under 420 of the IPC, my lord? There are page 14, if your lordship kindly sees. The allegation simpliciter pertains to a loan of rupees 55,000. My lord, may I read the FIR, my lord? I have the honor to inform you that one Jayanta Kumar Sharma, son of so-and-so, near so-and-so, who is working under SBI so-and-so, took a loan of 50,000 only on such and such to pay back me 55,000 within 20 February such and such of the rate of 10% per month. He also issued me a check amounting to rupees such and such, but when I submitted for withdrawal of money, the branch manager of bank informed me that no money is balanced in his account. Now, my lord, interestingly, he does not choose to initiate a proceeding under the NI Act. No proceeding is initiated under the Negotiable Instrument Act. He has rather filed an FIR which has been registered under 420. Now, my lord,
No complaint has been filed under NI Act.
No.
What is this?
Yeah, that is precisely, my lord. That's my case, my lord. That is precisely, my lord, why I am aggrieved. Because this does not constitute an offense under 420. There are catena of decisions. Your lordship is well aware.
Any record necessary?
Yes, your lordship, your lordship, there is a prima facie case, my lord. Prima facie, no, prima facie, actually,
Yes.
My lord, I'm not being able to hear. I'm not being able to hear.
yes, my lord. Page number 14, my lord. 298 itself, my lord. Come to Annexure 1, my lord. Page number 14.
Are we taking?
Uh, Yes, yes, now I can hear. Now I can hear.
Mr. T. Additional PP for the state. The PS case number.
My lord, Yes,
Number three.
your lords. Yeah. Now,
Item number 6.
Okay, why? Is there any case? Whether the respondent is contesting the case or contesting? Okay,
In fact, on the previous occasion, this court has given some time to the parties if there would be any compromise between the parties.
no compromise.
That process,
Procedure
yes,
still on.
yes, still on.
Okay. So we have objection? Yes, okay, Mr. D. Kamdar, Land Council for the petitioner. Sought for adjournment of the matter for 2 weeks. As he is
And-
yet to receive
My lord, there is interim also, my lord.
proper instruction from his client. The prayer made by the Land Council for the petitioner has not been objected to by Ms. Jeannie, Land additional PP, and Mr. G. Jeannie, Land Legal Aid Council for the respondent. Accordingly, the prayer is adopted. This matter after 2 weeks, stop. Interim order passed earlier shall continue till the next date of listing. Okay.
Withdraw.
Much obliged.
There is no case, it appears. Huh?
My lord, there is interim order, my lord, passed earlier. Has it
I
been
think I have
continued, my lord?
dictated.
Much obliged.
Item number 7.
Yes.
Your Lordship, yesterday, this matter was spread for an, for today, Your Lordship. As a mention memo was submitted and then it was set for today, Your Lordship. To that regard, Your Lordship, I have filed one affidavit, Your Lordship, to bring on report, Your Lordship.
What?
Your Lordship, there was an order that, if Your Lordship may refer to my, additional affidavit, Your Lordship. And if Your Lordship may refer to annexure number 1, Your Lordship.
Additional affidavit.
Your Lordship, that is an additional affidavit, yes, Your Lord. And if Your Lordship may refer to annexure number 1, Your Lordship, this is an order, Your Lordship, passed by this honorable court, granting an interim order to other party, Your Lordship. Thereafter, Your Lordship,
Just a minute. Which one is interim order?
if Your Lordship may refer to annexure number 1, page 127.
127.
Yes. And if Your Lordship may come to 130, Your Lordship, this is the
Just a minute,
operative part, Your Lordship.
130.
Yes, Your Lordship. If I may read, Your Lordship.
Yes.
In the view of the submission made by the learned counsel for the applicant petitioners, further proceedings of CR case number so and so state till the next returnable date, Your Lordship. Issue notice to the respondent in the interrogatory application fixed for the returnable date 19th September 2024, Your Lordship. This honorable court had granted an interim order for a specific returnable date, Your Lordship. Is till 19th September 2024. Thereafter, Your Lordship, on multiple occasions, this case was listed, Your Lordship.
Okay, now since it has been listed,
Yes, Your
let
Lordship.
us have hearing.
Since Your Lordship.
Listed for admission.
Yes, sir. It is listed for admission, and in fact, on 24th September, partial hearing was done, Your Lordship.
Okay,
So, Your Lordship, today we are ready for with the admission hearing, Your Lordship.
okay.
Yeah.
Yeah.
Your Lordship, I believe on my documents available with me, Your Lordship, the proceedings is not yet completed, Your Lordship. If Your
What
Lordship
remains
refer-
there?
Proceedings is not yet completed, Your Lordship, because if Your Lordship may refer to order date 7/8/2025, Your Lordship, they have prayed to file for an rejoinder, Your Lordship. And if Your Lordship may see the office note also, Your Lordship, they have not yet filed, Your Lordship.
Your Lordship, but in 29/9, in September 2025, it was clearly mentioned before the Honorable Court that we are ready with the admission hearing, and we are not wanted to file a rejoinder anymore. So on that day only, the partial hearing was done, and in fact, because of the short time period, the matter got adjourned after partial hearing, Your Lordship. So that is not the question now. For now, the important is, Your Lordship, partial hearing was done on September, so we want to continue with that partial hearing, Your Lordship, now.
Okay.
Yes.
May I correct, Your Lordship? There was no partial hearing was done, Your Lordship. If Your
Okay, whatever may be.
Yes, Your Lordship.
If you are ready,
Yes, Your Lordship. Your Lordship, my contention for today is, Your Lordship, the cancellation of the interim order, Your Lordship. Why? Because, Your Lordship, the.
Who
main
will
case, Your
dispose the entire matter?
Yes, Your
Will
Lordship,
dispose
that's
of
what
the
I
entire
was
matter?
saying.
For disposal, Your Lordship, I have received one rejoinder, Your Lordship, from them, Your Lordship.
Yes.
And this rejoinder has been, they have been submitted there, they are going to file, and then I have received, Your Lordship. And then this rejoinder is not available with your record, Your Lordship.
Your Lordship, but now we do not want to file rejoinder. That's why on that
How-
day we have made our
How
partial.
do I consider
hearing
that
admission.
additional documents submitted by them, Your Lordship? I have to get a fair submission of documents, Your Lordship, then only I can go for an admission hearing, Your Lordship.
What is there in the agenda?
Sir, there.
Any new-
objection or something were made, Your Lordship.
But they are not
this-
pressing for that.
Yes,
any
Your
longer.
Lordship,
So therefore, Your Lordship, why?
Whether it was filed, not yet.
not yet. No,
Then
we,
Now they don't want to
yeah, we
file.
don't want to.
So that's why, Your Lordship, I'm saying, for final disposal of this case, some more time may be given, Your Lordship. However, Your Lordship,
Tomorrow?
maybe tomorrow can be done, Your Lordship. But, Your Lordship, my only contention now is like that the interim order which was passed by this honorable court, that has to be vacated, Your Lordship. Why? Because Your Lordship,
Okay, tomorrow will do. Entire matter will be
Lordship,
disposed of
one
tomorrow.
reason why I'm saying is because, Your Lordship, one case, the case which is in CGN 0, Your Lordship, which
Hmm.
has been stayed by this honorable court.
That is why I'm saying.
It's listed for tomorrow there, Your Lordship. And now what they have done, Your Lordship, if Your Lordship may
No,
refer,
It was stayed.
was state. And
Then how it
thereafter,
has been listed
it
there?
was listed, Your Lordship, because they have never continued their interim order, Your Lordship. It was listed for 10 multiple occasions.
No, unless it is vacated.
Yes, Your Lordship,
Yes.
that's what I wanted to say.
One,
Then, okay, what we'll do?
one documents may be
Okay,
produced by Your
It,
Lordship.
it appears that you are not ready today, so we'll
Yes, sir.
fix it tomorrow.
Yes, Your Lordship.
Okay, entire matter will be heard. Okay.
One submission may be recorded, Your Lordship. Your Lordship may refer to annexure number 1 of my additional affidavit, Your Lordship.
Hmm.
How they have gone to this lower court, trial court, and then what submission they have made and what fault they have done before this honorable court. Your Lordship. We being an officer of a court, we have to be very transparent to this court. Your Lordship. Now, how the other party has played a role, that makes a huge difference, Your Lordship. If Your Lordship may refer to annexure number 111, Your Lordship, kindly please peruse, Your Lordship. At
Page?
page 157 of
One-
my additional affidavit, which was filed yesterday, Your Lordship. Page 157, Your Lordship. Page 157.
Yes.
This is order dated 16/10/2025, Your Lordship. Now, here submission made by them, Your Lordship, Learned Counsel, Miss M. Yama, for the accused is present and submit that inadvertently the stay order has not been extended after 19/9/2024. This was the submission made by them, Your Lordship. Now, Your Lordship may refer to annexure number 12, Your Lordship. The next annexure, Your Lordship. This morning, Your Lordship, they called to my associate counsel and seek for an adjournment with our concern, Your Lordship. We have granted an consent. Our consent was given, Your Lordship. Now, Your Lordship may peruse this order, Your Lordship. Now, 23/10/2025, Your Lordship. The same person, Miss Yama, Your Lordship, who appeared before trial court, Your Lordship. She comes before this court and seeks an adjournment. And thereafter, she makes in prayer that interim order passed earlier should be continued till the next date of listing, Your Lordship. Before this listing, before granting extension of this interim order, Your Lordship, 10 more occasions where case was listed, Your Lordship. In their entire orders, like none of the
Okay.
orders, they have extended their interim order. Therefore, Your Lordship, my only submission and my only request, Your Lordship, that the case which is pending before CGN trial court, that may be continued. And then since
Your Lordship, unless expressly this honorable court modified or vacate the state
So,
interim order, Your Lordship.
we'll dispose of the entire matter
Yes, Your Lordship.
tomorrow or
Yes, Your Lordship.
any day after tomorrow.
yes, Your Lordship, then
When you'll be ready, you just tell.
tomorrow is fine, Your Lordship.
Tomorrow.
Oh, Your Lordship, tomorrow case is fixing trial court, Your Lordship. Then
There is a stay. How it can be fixed?
there is a stay, Your Lordship. Thereafter,
That is why, Your Lordship, even,
2310 interim order passed earlier shall continue till the next date of listing.
yes, Your Lordship.
and it is very specific, Your Lordship. And my humble understanding of this giving him stay, Your Lordship, this is for a returnable date which is specifically maintained, Your Lordship.
What happened on the next date?
Thereafter,
Thereafter?
next date, like multiple occasions, this case of mistake, However, none of the orders it reflected that their stay was.
They did not even object it and they did not even file any IA for vacation, Your Lordship, for the stay order. And it was
No,
not,
this is the last order, it appears.
yes, Your Lordship.
Because
The last order also says that interim order passed earlier shall continue till the next date of listing.
Yes,
Till
Your
today,
Lordship.
till today.
So, Your Lordship, the thing is now, if
Your
the matter can be
this is only
heard
my-
today, Your Lordship, we can dispose of the matter.
It is still today.
Your Lordship, this is only my contention that how they have got this interim got extended, Your Lordship. Because just before that, the matter was listed on 16/10/2025 before CGM. They have admitted, the same council admitted that we have never extended our interim. Therefore, this case was listed before CGM. So therefore, Your Lordship, on 4/12/2025, that is tomorrow, Your Lordship, that is fixed before CGM 0, Your Lordship, for offense explanation, Your Lordship.
For?
Offense explanation, which is for tomorrow, Your Lordship. It's fixed for tomorrow. So
Your Lordship,
how-
and we came here for setting aside that order also, Your Lordship.
When
We are
there-
challenging,
when there is a stay order,
yes, Your Lordship.
probably the proceeding before the trial court cannot proceed.
Now,
Yes, Your Lordship.
It has to,
yes, Your Lordship.
it has been stayed.
Your Lordship may refer to the that
Now,
consideration which the another trial court had considered, Your Lordship.
Your Lordship, if the learned counsel want to praise this again and again, then I would like to argue today itself, Your Lordship. He keeps like taking things, Your Lordship, learned counsel, she is my junior. So if you want to keep this,
oh,
in-
no, don't take it.
yes, Your Lordship. So let's argue today, Your Lordship. It's better to dispose of this matter. I'm ready for today, Your Lordship.
Your Lordship, this is only my part of contention, Your Lordship. I'm submitting before honorable court, not against someone.
Just a minute, where was the last order passed by the magistrate court?
That is
Yeah, so just-
number 11 at page 157, Your Lordship.
Just a minute.
Which specifically says that the council says that inadvertently the stay order has not been extended after 19/9.
Yes, Your Lordship, and he has to read the whole part sentence. But it can be implied that the stay order will continue to operate since the IA criminal 74,024 in criminal petition is still pending and next date of hearing so and so. Try to read all the sentence.
Now, why and how it was listed on 16/10/2025 before the trial court?
Yes, Your Lordship, that is our
Your Lordship,
contention, Your Lordship.
matter was stayed on 28.
Because it was stayed,
It was stayed on 28/8/2024, Your Lordship.
yes,
So after a year,
unless the stay order is vacated, how it was, it got listed?
yes, Your Lordship. That is, Your Lordship. So this court, trial court has considered that only because after a year, Your Lordship, this multiple occasions case was dismissed before this court, and then interim order was never extended, Your Lordship. On that ground, that case was listed before trial court, Your Lordship.
We'll fix it for tomorrow, okay?
Okay, Your Lordship.
Let's pray for both the Lana Council for the party, list this matter again tomorrow, okay? Bye.
Highly obliged, Your Lordship.
Item number 10,
Yeah, no? Yes.
My lord, this is civil division petition, my lord. In fact, my lord, the issue involved here in this revision is that, my lord, petitioner, my lord,
Mhm.
and the respondent, my lord. They are from same village, same circle, my lord. Call, my lord, this what's it called?
So who appear for the respondents? Okay. We file wakalatnama Appeared earlier, not yet appeared. No one appears on behalf of the respondent till date. It appears. Hmm?
My lord, as per the causes, my lord, for respondent number 2, my lord, Advocate Bijay Jamo has appeared, my lord, once, my lord.
No, not yet appeared.
Oh,
While Wakalat Nama only.
But then, my lord, it is reflected in the causes, my lord.
Yes. There is a stay order.
Yes, my lord.
Okay. One more chance can be given.
Yes, my lord. No issue, my lord.
Hmm.
Otherwise, my lord, this honorable court, my lord, this court has, my lord, settled the issue, my lord. That they also placed the judgment or an order passed by this court, my lord, regarding the same issue, my lord. It was pertaining to the same issue, my lord. It is a case, my lord, where the petitioner and the respondent, though they belongs from this one circle,
Hmm.
but other circle has tried the matter, my lord, which is
Okay.
not permissible. That is the issue involved in this
Okay.
revision petition, my lord.
Let us give them one opportunity at least.
My lord, no issue.
Mr. G. Kamble, Planning Council for the petitioner is present. Staff now appears on behalf of the respondent, although Mr. Vijay Jamo, the name of Vijay Jamo. Yes, filed Wakalat Nana. Although Mr. Vijay Jamo filed Wakalatnama and his name has been reflected in the course list. Stop. How many respondents are there?
Only one, my lord. One is this private respondent is only one, my lord, and there is a state on the.
Oh, state respondent.
Yes.
Is there? Okay. For the end of justice, one more chance is given to the respondent for the appearance. List is matter after 2 weeks.
After 3 weeks, my lord.
After 3 weeks.
Yes,
Okay.
my lord.
Hmm.
My lord, there is interim order.
The interim order passed earlier shall continue till the next date of visiting. Okay.
Much obliged.
Item number 12.
Yeah, my lord.
Yes.
My lord, I may be allowed to file affidavit in opposition.
You are for the respondent,
Yes. Some more time may be given.
Mr.
T. Taggo.
P. Tago, Planning Council appearing on
Respondent. Sole respondent.
Planning Council for the sole respondent. So further, how much time you said?
Your Honor, 2 weeks maybe.
Further 2 weeks. Time to file affidavit in opposition. Prayer not been objected to is allowed. List is matter after 2 weeks. Okay.
Much obliged.
Item number 13.
On the last occasion,
Yes.
your lordship was pleased to decide on dropping of issues. And there was one.
Do you have any objection?
Yeah, regarding, Your Honor, regarding IA number 292, yes, I have no objection for dropping of this issue number 7 and 9, Your Honor.
Okay.
And my learned friend said he has no objection. My lord, on the last occasion, we have given a suggested issue. That somehow that issue was not considered when it was uploaded. And when we came to know about so on the last
The
occasion,
issue was actually this, I think that was framed in your presence only.
no, it was not framed in our presence. It was framed inside. It was decided, we have submitted, there was in the principal C. So somehow one issue, the suggested issue, issue number 4, somehow that has been missed, my lord. So on the last occasion, your lordship was pleased, again, my friend was pleased to just file an application in event I would like to get that issue. So only for that, IA number 305 was filed. And so far 292, yeah, very fairly, my learned friend has considered that he has no objection. But so far
305.
5,
This
What is
new,
this
new
written
IAS file. Yeah, Your Honor.
that
305 is for?
Addition,
Additional.
that one issue was, the draft issue was dropped, so it may be added. That is what my,
addition of issues actually.
Okay, you have objection?
Yes, I have objection. Your- I'm allowed to file objection, Your Honor, in this regard here.
because this was already draft issues which we have submitted.
No.
That was there in our suggested issue number 4. In our draft issue, it is already there.
Okay, but then the court while framing issues,
Yes, Your Honor.
But we have a pleading in that to that extent. We have met annexes to that extent. So then this is a very important, vital issue. So somehow it has been missed out.
what is the issue you are proposed to?
You know, we have, while filing the suggested issue, my lord, we only wanted to know whether the respondent number 1, the ICM trader, was valid as on 24/3/2024 on the day when he filed nomination paper. So as per the state government,
Yeah, no, which one?
draft issue, in the draft issue,
In the
filed
draft
by the
issue? Where do we find draft issues?
draft issue we have submitted, my lord. We have already submitted. And moreover, I have mentioned in my IA also.
Now, here in this IA for inclusion of the issues, you want to file objection.
Yes, Your Honor. I would like to file objection, Your Honor, in this regard, Your Honor. Regarding this IA number 305, which was filed yesterday.
305 has been filed yesterday only.
Yes, Your Honor. I have received yesterday only.
Because that particular issue was already there in the suggested issue, my lord. That was already suggested issue. I'm not pleading for additional issue which was not even considered. Draft issues by election capital. That was by. No, that is also included in my application 305.
Okay, if it is in the application and also in covered under the draft issue, probably it can be added at the later stage also.
Since Your
But then-
Honor, this issue is already framed.
If it can be added at the later stage also, why not now? Because since we are going to drop
Now,
this
I
item.
think, Your
issue
Honor,
number
this is-
7 and 9.
Your Honor, this issue is already covered under this issue number,
Which issues?
Draft issue
Draft issues number?
number 4. Whether the respondent of 1, being of already disclosed the trade license to ensure being valid as on 24th. Only this issue. And we are reading to this explanation.
even though it's maybe part of pleading, Your Honor. So they came with this IA. So I may give opportunity to find an objection, Your Honor.
See,
Any sort that may be given, Your Honor.
In the draft issue filed earlier, it is already there whether the respondent number 1 did not correctly disclose the trade license of Muslim trader being valid as on so and so. And Form 26. Affidavit filed by. Along with his nomination. Therefore, for the 9 child dozen. So this issue, according to you, covers under which issue?
I think it's covered under issue number 4 of framed by this honorable court, Your Honor. Whether the returning officer failed in their duty to properly scrutinize the affidavit submitted by the respondent candidate 136 of the RP Act. To my understanding, it's already covered under this, Your Honor.
But my humble submission would be, this is as regard one particular trade license. This is a very core issue in the sense that if that trade license were in existence on 24/3/2024, he is disqualified by the operation of law. Because so far the government is, state of Arunachal is concerned, a sitting MLA cannot have a valid trade license. Then that is my case, even in my page 159 of my election petition, I've annexed a particular paper,
Just a minute. Huh?
my lord.
So this covers under, according to you, covers
Yes.
under issue number 4 of
4 years.
okay, 4 framed by this court. Whether the returning officer failed to, no, which one? Issue number? This may not be, this may not be the one.
Issue number 4, Your Honor.
Issue number
4.
4 is, kindly read it.
Whether the returning officer fail in their duty to properly scrutinize the affidavit submitted by the respondent can under section 36 of the RP Act. Your Honor.
This cover vast question. Since it is in the draft issues, can be, I think, included these issues.
Look, may I make a humble submission, Milord?
Hmm.
If your lordship please. Issue number 3, where the honorable court was pleased to frame issue number 3. If I respectfully take Milord with issue number 3, whether the respondent elected can fail to disclose material information. Milord, why I'm worrying is the material information may include the trading license, but it says such as criminal antecedent / mobile agent / trading license. That would serve my purpose also. Because some part of that thing is already there, but I just, because as this being an election petition, my humble submission is that I would like to specify that /
Yes.
license. It can also be.
Otherwise, this covers under this.
Yes, sure.
No. because.
But then you want a specific,
Because
issue.
that.
Only the thing is specifics, not.
There is specific reading to that extent.
Because failure to disclose cover under this.
Failure to disclose material.
But then while in the evidence, you can bring it
My lord, if your lordship pass an.
in the same issue number 3.
No, if, my lord, would like to elaborate because trading license is a particular and different category issue, but it says material information. At the time of framing also again because it's an election petition. Had it been such as criminal antecedent, immobile assets, trading license, my lord, I could have understood that.
Whether the non-disclosure of Mr. English's pet so and so has materially affected the election result, and you said it's all the same, almost.
My lord, yes, almost. Therefore, my only humble submission is almost same. So if it is specified, my only humble submission that needs to be specified. In one sense, your lordship is right. I just want that specification.
So if it can be the sentence, including the non-disclosure of the trade,
Trading license.
including the trading license, trade license of message so and so
Being valid.
being valid as
Yes,
on
on-
so and so. Only that much is not covered.
That is
according.
not covered in that. And if you decided, my lord, my purpose is just that very categorical word that it was valid till 24/3/2022.
Such as criminal antecedent, immovable estate, and
And
not correctly disclosure of the trade license so and so.
being valid as on 24/3/2024. That will
This
also,
can be corrected by including this.
but that also would serve the purpose.
The issue number 3 will remain the 3. In issue number 3, only one this can be included. One within bracket, that is also such as criminal antecedent, immovable asset, then stroke, then
Trade license of HM traders.
trade license of Messrs. HM Trader being valid as on so and so. That much can be included because this is covered.
Covered. I just want that.
If your honor decided to allow this application, then my objection may be recorded, your honor. That's all. I have an objection, your honor.
Okay.
Otherwise, I may allow to file objection in written form. Any sort that may be given you.
Object. So by what way you are going to object it?
So,
because
Your Honor,
it's already there in the draft.
this honorable court
and
is
in the
already
pleadings also.
this honorable court has already framed the issue
Maybe, but
and entering at this stage, entering new word to this same issue
it's not a
is
new
amounting to like
not a new-
amendment
it's a
or
pleaded
kind
case.
of like
It's a pleaded case. And
Though it's a
it's
pleaded
already in the draft issues also. So which was left.
then my objection may be recorded, Your Honor.
Okay. Or Mr. MGC. Land Council for the applicant stroke election petitioner. And
And
Mr.
Mudangopo.
Hmm?
Mudangopo or sole respondent.
Okay. Land Council for the respondent staff. Para. Para, on 28/10/2025, this court framed altogether 11 issues. Including the issue number 7, which read as it is in order dated type issue number 7 and 9, which read as okay. 7 is whether the respondent elected candidate is guilty of corrupt practice as defined under section 123(2) of the Representation of People Act 1951. So more particularly for alleged booth capturing, malpractices and rigging at the polling stations pleaded in the petition. And 9 is whether the allegation of booth capturing, malpractice, rigging, etc. lacks material particulars as required under Section 135A, Representation of the People Act 1951, for making out a cause of action of commission of corrupt practice under Section 100, within bracket 1, within bracket small b, Representation of People Act 1951. Paragraph. By filing this misapplication, number 29, sorry, just interlocutory application IAC number 292 AP 2025. The applicant stroke election petitioner prays for dropping stroke deletion of the issue number 7 and 9 framed on 6/11/2025 as not pursued. Stop. The para. The Adani Council for the respondent has no objection deletion of the issue number 7 and 9 from the issues framed on 6/11/2025. Stop. In view of the above, the issue number 7, in view of the above, this court find no impediment to delay and to allow the prayer of the applicant stroke petitioner for deletion of the issue number 7 and 8 from 8 from the issue framed by this court. Stop. Para. Accordingly, the miscellaneous application is allowed. The issue number 7 and 9 is dropped, stroke deleted from the issues framed by this court on 6/11/2025. Stop. By with the above this IA stands disposed of by another interlocutory application IAC 305 AP 2025. The applicants, election petitioners seek inclusion of the issue number four of the draft issue submitted by the election petitioner. Is it so? That the issue number four read as under whether the respondent number it is where is the issue your draft issues is okay your draft issue is has it been paginated? Okay. Whereas, whether the respondent number one did not correctly disclose the trade license of Messrs. HM Traders being valid as on 24/3/2024 in Form 26 affidavit filed by him along with his nomination paper for the 9 Chayang Tajo within bracket ST Assembly constituency in the 11th Arunachal Pradesh Legislative Assembly election 2024 and whether such non-disclosure would be corrupt practice of undue influence and the same materially affect the election of the respondent number one or not. It is submitted that while framing issues, the above issue number four of the draft issues submitted by the election petitioner, applicant stroke election petitioner has not been included. What is the IA? The another IA? Okay, okay. This is the it is submitted that the omission of the proposed issue number 4 submitted by the applicant election petitioner requires consideration, as it goes to the root of the controversy and is essential for proper adjudication of the election petition staff. Para, the Learning Council for the respondent raise objection and submit that since the court has already framed issues what is your submission? You said why you are raising objection?
Your Honor, my objection only this issue number 4 already covered.
Okay. As it already covers under issue number 3.
No, issue number 4 is already cover the issue which is
Within the issue
proposed.
number covers under?
No, issue number 4, issue number 4 is already covered.
Under which issue?
No, issue frame, but it's honorable court, Your Honor. Because there,
issues framed
Yes, yes.
cover
because
under the issues framed by already framed by this court. Start.
yes, Your Honor.
Okay. Mr. Singh, Learning Council, fairly submits that although the issue number 3 submits that the issue number 3 almost cover, however, it has to be specifically mentioned. Where is the issue number 3? Just a minute.
You will find in the petition based on the page. Based on the page.
No, whether the respondent okay. Okay, Mr. Singh, submits that the issue number 3, which read issue number 3, which read as issue number 3, whether the respondent elected candidates failure to disclose material information within brackets such as criminal antecedents, stroke immovable asset, bracket close, in Form 26 amounts to a violation of the Representation of the People Act 1951, particularly Section 33A, and if so, whether the non-disclosure or misrepresentation of fact in Form 26 has materially affected the election result and vitiate the respondent's nomination, covers the failure to disclose material information. However, the mention of not correctly disclose the trade license of MS HM Traders being released as on 3/2024 would be sufficient. would complete the issue as prayed for, or what?
If that is not strictly mentioned,
Okay. In view of, okay, para, in view of the above, the issue number 4, in view of the above, the prayer of the applicant petitioner shall be, for inclusion of the above sentence shall be incorporated in issue number 3. Stop. The issue number 3 now shall be read as, okay. Whether the respondent elected candidate's failure to disclose material information within bracket such as criminal antecedents, stroke, immovable asset, stroke. And what was that? Disclose,
non-disclosure of trade license.
non-disclosure of the trade license of masses HM Traders being valid as on 24/3/2024 within bracket, in form number, in form 26.
Information is already there.
Okay, form number, okay, and bracket close, in form 26 amounts to violation of the Representation of the People Act 1951, particularly section 33A, and if so, comma, whether the non-disclosure or misrepresentation of the fact in form 26 has materially affected the election result and vitiates the respondent's nominations. Okay, inverted comma close. With the above, the IA stands. The IA stands allowed to the extent as indicated above. Okay, and dispose of. Okay, this IA also dispose. Then now we have now the issue number which we have now deleted 7 and 9. This probably is to say serial number of the issue is to be changed now, because now 7 and 9 dropped. Now there cannot be a gap in between. So
That nomenclature will change.
this number of the issue number will be changed. Now, final then the
Renumbered as, it will be renumbered as.
okay. Then with the above, the issue of the election issue framed by this court, the issue of election petition number 1 AP 2024 framed by this court on 28/10/2025 shall renumbered as renumber and read as, then issue will be again on that page is in order number so and so. Okay, then you in the above you type issue of election petition number 1 AP 2024 1 2 3 3, that this modified one. Okay, 4 5 6 7 drop, 8 will become 7. Okay, 9 drop, 10 will become 9, and 11 will become no. So 8 will become 7, 9 will become 8, 10 will become 9, and 11 will become 10. No, how? 2 has gone down. No, this 6 and 7, 8 will become 7. Then 9 will become 8. Is it?
No, 9 doesn't go.
9 is,
7 and 9 is gone.
sorry, 10 will become 8, huh?
Yes. And 11 will become 9.
11 will become 9 only. Now only 9 issues. Okay? Reframe, huh?
And look, if your lordship is pleased, because I have to execute the document.
Yes, this sentence will be corrected. So this is done. Okay, those two IA disposed of today. And then issue reframed, renumbered. Okay. Okay, now what next?
Next is that your lordship has to give a date so that we can exhibit the documents.
Okay.
Or your lordship is pleased. Your lordship may kindly appoint any of our learned counsel to be AOR only for the exhibition of document, because it may take.
How many documents are to be exhibited?
Altogether, I need to exhibit 35.
35.
35 documents. So, my lord, to be very fairly, I wouldn't like to disturb your lordship's valuable time.
Now, only the thing is that your serial number, name of the documents is to be named, and an exhibit number. Have you typed it properly?
Because that has to be exhibited.
No, just for the convenience of the court. Let the court also will say. Court also will say, if you can type it out, serial number, name of the document, and exhibit number. So if you can type it, then because it will be a continuation of your deposition affidavit.
That can be done.
So that will do, and then you type it properly, show it to him also. Okay, give a copy to him. And in this court on that day, on the next day, yes,
But unless I get direction from your lordship, I cannot do that. That's
yes.
As your lordship has directed me, I'll do that.
That will be, I think,
It will not consume time also.
Very appropriate here.
It will be appropriate. So your lordship may kindly fix any date so that I can submit.
right. Then in the, again in the May, huh? That order also will be here in this main also. Okay. Then it will be continuation of this order only then. So that order will be, you have to type for the both miss case also, and then here in the main case. Okay. Okay, Mr. I'm just allowing counsel for the applicant election petition. Election petitioner. Now, what we'll say that the document to be executed by the election petitioner. So, no, sorry, the direct counsel for the petitioner shall typed out the document to be executed in the election petition. And submit before this court. And a copy may also be furnished to the land council for the respondent. The exhibit shall be marked on the next date. Okay, we just typed out. And then on that day, that will be reduced here. They'll bring here in in continuation of your application. Yes, deposition. So that will hardly cover two, yes, 2 to 3 pages. Because if he approved, then we'll just get it typed here. Okay, approved means if he consent, agreed on the proposal. Then deny, that will come later on only. But it will be marked at the moment. Okay. The next day you submit. So when do we fix?
Mine is sooner the better because I'm the election.
Yes, yeah, that is why.
Any sort that your lordship.
Now, next roster has not yet come.
But that I can submit it. It can be through BC also. Last time it should
Oh,
be.
BC, okay. Then in that case, next week, it would be little difficult. Thereafter, next week, okay? Okay, as agreed upon by both the Land Council for the party, let this matter be listed again on
December.
December.
Nine. Lordship will have difficulty next week. Then, if it is 2 days.
Next week it will be.
Can it
then
be
14, 15, 14?
Can it be in the second week starting from 8 if your lordship is pleased?
Second
Maybe
week?
11, 12, not 14. 15.
11, 12.
Is your lordship please?
No, most probably what 14, 15, from the week starting from 14, probably this court will sit with
Okay, yeah.
Tanagar.
Okay.
And then 7 to 11, this court will not be here.
Okay.
So then it will fix it on, Oh, yeah, 26. Okay. Sorry, it's all the same, almost. 15, it starts from 15 that week. 16, okay. This is matter on 16, okay.
In fact, I wanted a very short day because it can be done through BC also.
But
yes, your lordship has given the option, maybe economic in profit goods that exhibit.
Okay.
16.
16.
All right.
Yes.
Can we give for both the PWs?
Yes, both the PWs. How many? Okay, PW1.
Thereafter, the lordship has.
PW1 will be exhibiting 35, around 35 exhibit. And then 2, probably not.
Some, but then we almost.
2 will be very less. Okay.
And thereafter, when we have to decide on 2, then I call for the official witnesses.
Okay.
All right.
Okay.
My lord, I beg your pardon to interrupt the proceeding, my lord.
Yes.
My lord, in item number 12, when the item number 12 was called, I was on legs before court in court number 2. Now I've been informed by my brother who is appearing for the respondent that he has sought for 2 weeks time. But I just want to express this court that there is an interim order operating.
Okay, in item 12, interim continue.
That may be extended.
Okay.
Obligation.
Item number 14.
Okay. Mr. Land Council for the petition. Sorry, is present on behalf of Mr. L. Land Council for the petitioner. Mr. You are appearing for the first time. Earlier also appeared. Mr.
Siraja.
Land Council would appear on behalf of the respondent number.
Sole
Okay, sole respondent. So, and prays for some time to go through the petition and to file response if necessary. Stop. Let's pray for this matter after 3 weeks. Okay. The interim order, what interim order was there? The interim order passed earlier. Shall continue till the next date of listing. Okay.
Item number 15.
Lordship, this is jail appeal, Lordship, and Lordship. Notice has been served upon victim, Lordship, as per number.
Notice was issued.
Yes, Lordship,
To the
but
victim.
report has still awaited, Lordship, service report.
Whether the victim was included.
Lordship, this is jail appeal, Lordship.
Yes, it's included. Okay. You are Miss
Didimi.
Legal Counsel?
No, I'm appearing on behalf of C. Modi. Amicus.
Learned Counsel for Learned Legal Counsel. Mr. Miss Remy appear on behalf of Mr. C. Modi, Learned Legal Aid Counsel for the appellant. Stuff, the notice upon the victim. Respondent also it's awaited, I think.
Lordship, there is not Lordship, only one private respondent, Lordship. A
Mhm.
victim was other is state, Lordship.
Okay, okay. State is one.
Yes, Lordship.
So the notice upon the newly implemented victim is still awaited. In view of the above, let this matter be listed after 3 weeks.
Yes, Lordship. Lordship, in the meantime, paperwork may be prepared because TCL
Okay,
already shipped, Lordship.
The trial court record has been received. The registry, in the meantime, shall prepare a paper book.
Lordship.
Okay, and furnish a copy to the council, appearing on behalf of the parties. Okay.
Lordship. Much obliged, Lordship.
Item number 16.
Mm.
I'm on behalf of Kingdom. This is a criminal.
Mm.
Was called PCR code.
Is there any private party here?
Yes. 2 and 3.
Where the private party is appearing?
No, Your Lordship, the notice is yet to be completed. Let's see.
But the respondents are not appearing. But the notice not yet complete.
Not yet completed. This is the second time.
So who is respondent number 3?
Respondent number 3 is the mother of
Informant.
DPR said it was served.
In that case, your lordship, if the parties are not appearing, your lordship can appoint an
But
then-
victim probably.
because victim is respondent number 3 is the
The
mother of
3 served through husband. 2 not yet.
otherwise, your lordship, 2 is being represented by
It's all the same.
same because respondent number 3 is the informant who is the mother of the
Mhm.
minor child.
3 is the mother,
Yes,
and the notice upon the 3 was served through his husband. And then since the husband, wife, there are parents of 2, I think,
deemed
Mr. Lana counsel for the petitioner is present. The appellant is present. Mr. Tijini, Lana additional PP is also present. Staff. The office note dated 28/11/2025 reflect that the notice upon the respondent number 3 is returned after served with. However, no one appears on behalf of the respondents. So they are the complainant, yes, or informant. Just a minute.
informant, your lordship.
Let us confirm if we can appoint.
Your lordship will find at page number 82.
82.
Yes. Chart sheet.
What is that?
At serial number 9, name of the complainant informant is the present respondent number 3.
Okay. Where do we find the FIR?
FIR is not annexed.
It has been annexed? No.
No,
Okay.
your lordship will find at page number 128.
FIR is thinking, page number 171.
170.
Probably they might contest it appear.
That your lordship in that case may.
One more chance can be
Yes.
given. Okay. Hmm. Oh. In the interest of justice, one more chance can be given to the respondents to appear and contest the case. Stop. In view of the above, let this matter be listed after
2 weeks, your lordship.
3 weeks.
3 weeks.
Item number 17.
Deeply.
May I, Lordship?
Yes.
On the last occasion, the TCR was called for, your Lordship.
Just a minute. In earlier case, PCR is still awaited. No? The trial court record is still awaited. Okay. In view of the above, let this matter be listed after 3 days. Okay. Okay. Ms. T. Rini, Lana counsel for the petitioner is present. The trial court record is called for, it is still awaited. In view of the above, let this matter be listed after 2 weeks. Stop. The registry shall issue reminder for trial court records. Okay.
Item number 18.
May I, your lordship?
Yes.
Your lordship, I'm appearing on behalf of N. Pada in the present matter.
Yeah.
That we have already obtained consent for adjournment from the other parties. Here we are supposed to file objection.
Yes, yes.
Few weeks.
You want to file objection? You're for the petition. Okay.
So
You want to file objection?
Yes.
How much time you are praying for?
3 weeks.
Mr.
Tijamo.
Hijamo, Lana counsel for the respondent, pray for further 3 weeks time to file response. Stop, Mr. Sorry. R. For Lana counsel for the petitioner. To which the Lana counsel for the petitioner, R. Koilana counsel for the petitioner has no objection. They are allowed. List this matter after 3 weeks. Okay.
This thing.
The interim order passed earlier shall continue appeal the next date of this. Okay.
Obliged.
Item number 19.
Yeah.
My lord, it's a criminal appeal against the conviction, judgment, conviction and sentence for 10 years in a POCSO matter, my lord. So here, your lordship, they have taken steps through public office of public prosecutor, and accordingly, your lordship, we have forward the relevant documents to the concerned OC, your lordship. The service is yet to be received, my lord. It's not completed.
Okay. It's a jail appeal.
Yes, my lord.
Now, whether have we appointed?
No, ma-
You're
I'm on behalf of you, Body Lordship, the Legal Aid Council.
okay. Pori is legal aid counsel.
Convicted person, yes.
Now, probably formal.
My lord, service has to be completed first. Then, if they doesn't appear, turn up, then only your lordship may please to appear a legal aid counsel on behalf of the victim. But now the service is still not completed.
Now, there is no appeal memo.
Yes, my lord. They
Legal-
have to prepare
legal
it. Yes,
counsel has to
absolutely.
file probably
Yes, your lord.
appeal memo.
Yes, your lord.
And here on the first date, mistakenly it was typed admit.
Yes, my lord. And TCR was also called for. Now, your lordship, on the base, since the TCR has been received, a copy of TCR may be furnished to them to the registry so that they prepare the necessary appeal, memo of
Now,
appeal.
now probably along with the memo of appeal, if there was any, because it appears there was some delay.
Yes, my lord.
So they also have to make a prayer for condonation of delay also.
Yes, my lord. Now, the one more issue is, my lord, if it is admitted, my lord, then, my lord, IA is not required because
No, that-
only, but if whether it is admitted or not, that has
No,
to be.
no justification, but admit, only admit.
Okay.
So this probably was mistakenly typed.
Yes, your lord. That means it is not admitted, your lordship. They have to file IA for condonation of delay. Or in memo also, your lordship, they can make a ground for such delay. Make
The Learned Legal Aid Council. So, no, he was already asked to file a proper memorandum of appeal.
Okay, your lordship.
Miss
M. Borilas.
Learned Counsel, appearing on behalf of Mr. U. Bori, Learned Legal Aid Counsel for the appellant, prays for further 3 weeks time to file proper memorandum of appeal along with the prayer for condonation of delay in filing the connected appeal. Stop. Mr. Learned additional PP is present. Stop. The trial court record has been received. Since the trial court record has been received, the registry is directed to prepare paper book and furnish copy each to the Learned Counsel appearing on behalf of the parties. Staff. The office note dated 7/11/2025 reflect that the notice upon the victim.
Yes, my lord.
He is still away. No, hasn't received. Probably it was served.
My lord, the steps has been taken, but it's not received. Is still not received, my lord. Awaited, your lord. Steps has been taken through concerned OC, your lord.
No, so it has received. Returning of service, served notice. I'm returning. So it's from OCPS drawing.
Okay, my lord, whether there is any acknowledgement by the victim or the victim family, my, that has to be ascertained.
There is no signature as such, but then says that information says that it was served.
It has to be
There is signature. Sonar. Yes, there is. Office note dated 7/11/2025 reflect that the notice upon the victim has been served and received. Received by the victim. However, no one appears on behalf of the victim. So if on the next date, the victim still remain absent, then we will
Yes.
appoint one.
Legally counsel. Yes, sir.
Okay.
Yeah.
So now for the time being, since this also is to be prepared,
Yes.
we'll get it listed after 4 weeks then.
Yes, Your Lordship.
Okay. No one appears. Okay. In view of the above, the victim is also given one more opportunity. Is given one more opportunity to appear and contest the case. Stop. List this matter after 4 weeks. Okay.
Obliged.
Matter number 20.
Lordship, I'm for respondent number 47, 48, 49, and 50, Lordship.
Okay.
I'm appearing for the first time, so I need some more time to file the affidavit in opposition.
You are Miss
Embore, Lordship.
Lana Council for the Lana Council could appear on behalf of the respondent number
47, 48, 49, and 50.
47, 48, 49, and 50. For 50. You have filed Wakalat Nama.
Yes, Lordship.
By filing Wakalat Nama, stop. The office note dated 2/12/2025 reflect that the trial court record has not yet received. In view of the above, let this matter be listed after 3 weeks. Okay.
Obliged, Lordship.
Matter number 21.
In that case, no one appears on behalf of the petitioner, huh? Okay.
My lord, I am appearing for the respondent. The respondent has filed her affidavit in opposition and the pleadings are complete, my lord.
Okay. Mr. Ibaum. You are for the
I am
respondent?
for respondent. Ketas.
Okay. No one appears on behalf of the petitioner?
Uh,
No one appears for the petition. You are for?
I'm appearing on behalf of IBAM, Your Honor. My lord.
Okay.
For the
Mr.
appellant, M. Ratan, ma'am.
Lana Council appear on behalf of Mr. Ibaum, Lana Council for the petitioner. Mr. Ketaso, Lana Council appear on behalf of the respondent.
Yes.
How many respondents?
The sole respondent.
Okay, sole respondent. It is submitted that the pleadings are complete and the matter is ready for
Hearing, ma'am.
hearing. Okay. What about whether the record was called for here in this case? Hmm? Whether the record is necessary? So civil revision petition against what? Expired evaluation, okay. So, whether record would be necessary here in this case?
My lord, that
Record can be called, my lord.
Okay. The Lana Council for the party submits that the record of the Keba or
Gaba.
would be necessary for proper adjudication of the case. Accordingly, call for the relevant records. So Keba records are to be called from where?
Customary court of Ngomdir village, my lord. West Siang district.
Okay. As prayed for, Kama, let this matter be listed after 3 weeks. You pray for some time, isn't it?
Yes.
No, okay, just a minute. Huh? In the meantime, record call for the record. Huh? Okay. So then this will be listed for admission.
Admission.
Okay. List this matter after receipt of record. Comma list this matter for for admission. Okay,
My lord,
After
interim,
receipt.
interim is there, my lord.
the interim order passed earlier shall continue till the next date of listing.
Deeply, your lord.
Okay.
Item number 22.
Your lordship, in item number 20, it has been informed that the matter has been charge sheeted, your lordship, on 26/7/2025. In that case, TCR may be required.
Okay, earlier case study was called for.
Yes.
Okay. Miss Jenny, done additional PP for the state submits that during the pendency of this petition, criminal petition, the case has already been submitted into charge sheet. In view of the above, let a trial court record be called for. Staff, please this matter after
2 weeks, your lord.
2 weeks. Mr. D. Kamdar, Direct Counsel for the petition is also present. Okay.
Deeply.
This is TCR.
No, that is only the bail application that they have filed before the trial court.
Okay.
I've checked it.
Okay. Scan copy of the trial, TCR, trial court record.
Deeply.
Okay.
Item number 23.
Your lordship, the registry is yet to receive the TCR, your lordship.
Yes. Yes. Mr. Deori, Line Counsel for the petition is present. The trial court record is still waited. Which court?
Konsa.
Konsa. In view of the above, let this matter be listed after 2 weeks.
The 3 weeks.
After 3 weeks. Okay.
And I will pray with the status quo. Right. Okay. Okay. God bless. If trial court record is coming anyway.
Okay.
Deeply.
Item number 25.
May I please, my lord? My lord, the service report is still awaited upon respondent number 2. So kindly allow me to take dusty service, my lord.
In view of the office now dated 2/12/2025, Mr.
M. Ratan, my lord.
Land Counsel for the petitioner praised for allowing him to take fresh steps upon the respondent number 2. The prayer is allowed. Notice upon the respondent number 2 be taken by a speed post as well as by user process within a week from today. Let list this matter after 4 weeks.
My lord, after
weeks.
1 week, my lord, because this is cancellation of bail, my lord.
Cancellation of bail.
Yes, my lord. There is an urgency, my lord.
Hmm?
Yes, my lord. So kindly matter may fix on next week, my lord.
Then where this respondent stays,
Itanagar, my
you are
lord.
going to take steps upon
Respondent number 2, my lord. Upon dusty service, my lord. Dusty service may be allowed, my lord.
the stay.
Yes, my lord.
Okay. Then praise for allowing him to take fresh steps upon the respondent number 2 by way of dusty mode. The prayer is allowed. Steps upon the respondent number 2 by dusty service through to be routed through the register within
3 days, my lord.
3 days from today. Stop. List this matter after a week. Okay.
Okay, my lord.
Mr. Kurdu Lanet, Special PP. Special PP.
SIT matter.
SIT is also present. Okay.
Deeply
Alright.
impressed, my lord.
Item number 29.
May, your lordship.
Yes.
Your lordship, this is a part-hard matter.
Hard matter.
Yes. This has been hard twice, your lordship.
Okay.
This is a second appeal, your regular appeal, your lordship. I have I have made a written argument, your lordship, for convenience of your lordship,
Okay, please.
along with one citation.
Okay.
Your Lordship, a title suit for declaring 3,780 square meters of ancestral land located at Tirbin, which was conditionally donated by agreement letter dated 06/1977. Your Lordship, it was occupied by the respondent's authority. So being aggrieved, Your Lordship,
Just a minute. Just a minute.
yes.
You earlier filed title suit before the chief judicial before the civil judge.
Yes. I
That was
filed
that
title
was
suit
dismissed.
before the ADJ Basar, but however, because of,
That was dismissed.
no, it was transferred to CGM Alo, then it was dismissed.
Okay.
CGM, it was numbered at ADJ Basar, but however, since it do not have the, as per the provision, so it was transferred to the Civil Justice Division
Okay.
Alo.
It was dismissed.
It was dismissed. Then I appealed before again, ADJ Basar.
Hmm.
Then I am here.
Okay. Appeal also dismissed.
Yes, appeal also dismissed.
Okay, so this is second appeal.
Yes, this is second appeal. So accordingly, while hearing in the motion, your lordship, by order dated 08/01, substantial question of law was framed by this honorable court.
Two.
Two, yes. It's in order dated 08/01/2024. So basing on these two substantial question of law, we have to place forth our argument today, your lordship. The substantial question of law formulated.
Appeal was also not contested by the government.
Yes, it was all ex parte, your lordship.
Okay, but then it was dismissed.
Yes, it
Okay.
was dismissed, having with observation that I have no cause of action,
Hmm.
wherein erroneously the lower court has passed this order. That's why I'm here, your lordship. They've overlooked the documents on record.
So only two substantial questions.
Yes.
Law.
Yes.
Whether the title suit filed by the plaintiff appellant is barred by the limitation of law.
Yes. That your lordship, if your lordship
But
allow.
you filed title suit after the expiry of the
Yes.
expiry of 3 years.
Yes. My land was donated in the year 1977. I filed a title suit in 2016. So they are saying that you have come for title suit sleeping over 40 years. So they have straightway counted cause of action from the year 1977. They've overlooked vital documents, which I would only peruse. Here, your lordship, there is only one point. If we can determine the point number one, then second one, your lordship, this matter can be reverted back for trial at the lower court, your lordship. For clarity, may I take your lordship to
Just a minute.
read
huh?
document?
Hmm.
Yes.
Probably now we have only 15 minutes,
Yes.
but we'll have to continue at 2. Just a minute. Yeah. Lane was donated on which year?
1977, your lordship.
77.
Yes.
And and according to you, that so while donating the land, whether any agreement was executed?
Yes, there was two conditional agreement, your lordship. It's in page number 31.
Just a minute. Huh?
Yes.
What was that condition?
A soap license was to be given to me.
Given to you?
Yes,
License?
and yes, any wanted facilities.
Yes, soap license given to you?
Not given. And any wanted facilities, that is, which includes the compensation, since all my horticultural ancestral land was uprooted. So on that condition only, your lordship, I will only argue on 2 points, your lordship. On that condition, it was donated. In the year 2000, and may I take your lordship to?
Just a minute. Yeah.
Yes.
Not yet started. Just let me recall the basic condition. Okay, now you tell me. On what basis you are claiming the state land to be your land? First, let us see your claim.
Yes. On the basis of this agreement, Your Lordship, there, on the basis of this agreement,
No, no. On what basis you are claiming the land to be yours?
it is established in the all the documents, Your Lordship, that it is located in the heart of the Tribune.
Okay, heart of Tribune, but
Yes.
how can you say that that land belongs to you?
There is as per the order of the Planet Trial Court, there is
No,
also
forget about the trial court.
Yes.
Before donating it to the government,
Yes.
what is the documents available with you that showing that that land belongs to you?
Prior to that, Your Lordship.
Not before, not after.
Yes.
After that, because on the basis of your claim, the court will make some observation. Okay.
Yes.
Court will also, because on your claim, you have claimed that you claim this land, so and so. So, okay, forget about that.
Yes.
Prior to the donation agreement, prior to that, you says that that land belongs to you. How that land belongs to you?
That is my ancestral land. There is no written record. However, that is the precedence how tribal community occupies a land. And there
No,
this
maybe,
question.
but then any certificate from the local authority?
No, 1977. No, nothing, Your Lordship. At that time,
LPC.
no, nothing, Your Lordship. At that time, this is of 1997, Your Lordship. 1977, Your Lordship.
Okay, then how your land was approached by the government?
By sending a public interpreters, political interpreters, because in order to establish IDC headquarters at Tirbin, land was required, Your Lordship. So they had at those time they had sent deputy commissioner has engaged political interpreters to acquire land by calling up the public.
By any written order?
No, as per my records,
Now, political interpreter, whose man is this political interpreter?
they works under the supervision under the.
That is what I'm saying.
Yes.
He must have been directed by the deputy commissioner.
Yes.
To go.
Yes.
By an order.
Yes. That order is not available, Your
Okay. Then on verbal.
No, as this suffice, this is the agreement wherein their signature, this suffice, Your Lordship.
Whose signature?
This political interpreter signature.
Political interpreter. Okay. Forget about political interpreter.
Yes.
Because political interpreter, we do not know whether he was a political interpreter was your man or whose man. We do not know.
Yes.
Is there or was there any government, any order, direction to the political interpreter to go and negotiate with you?
Those things, Your Lordship, whatever Your Lordship is pointing has to be decided in the trial court level, Your Lordship. I was not given chance at the first instance only. My trial.
This is basic question.
Yes,
to establish, to show that the land belongs to you.
Yes.
Because now you are claiming after long, because it was over, way back in the 77. In those days, you see the government used to acquire land.
Yes.
The people used to donate for establishment of headquarter, okay, circle headquarter, etc. Okay, without any cost, without any agreement, without any execution of any agreement between the parties, or without any condition.
Yes.
So that was the situation. Now, this court would like to know what was the situation or condition with you. Is there any written document?
There is no written documents as
Then
such.
on what basis you are claiming that this land?
On the basis of this, I am saying that my title suit was that they are illegally occupying my land. My title suit basically has 2 points. One was that they have not rightfully acquired under the Land Acquisition Act, and they are illegally occupying my land. And number one is that I am the owner of that patch of land, so I should be given back that land. Now, and without going through the merits.
Is there the government maintain the cadastral map and all that this land belongs under this circumference, the land belongs to the government, etc. Whether the government maintain cadastral map?
That I am not aware of, Your Lordship. However, Your Lordship.
That is necessary because if it is a government, if it is a no man's land, it's a government land.
No,
in the state of Arunachal Pradesh.
They have I have annexed some documents wherein they are admitting that that land belongs to us. The government is admitting, Your Lordship. Basing on these points, I am before Your Lordship.
When and how the government admitted that?
Your Lordship may peruse this page number 70 of my annexure, Your Lordship. Page number 70. This is a deposition filed before the Chief Judicial Magistrate by the respondent number 4, that is Executive Engineering, who is occupying my land. They're saying, Your Lordship, this is to the Chief Judicial such and such, allow title suit number 20/6. Yes, number 2, I'll read the relevant portion, Your Lordship.
Page
70. Page 70.
Yes.
Annexure 11A, Your Lordship. This is the deposition filed by the respondent number 4, Executive Engineering, who is occupying my land. In serial number 2, he has said, as per serial number 2 of donation letter dated 07/03/1977, Sri Yorkop Gade has been awarded contract work amounting to such and such when work were carried out within the donated land. Copy of work order enclosed. Such copies submitted for your perusal and order, please. This record shows that, Your Lordship, they are admitting that that land belongs to us, belongs to me.
No, you have to first prove that you donated the land. This is letter.
Yes.
This is letter on 2016.
Yes.
Very recent. We do not know who is this officer.
This.
So where is the agreement?
Agreement is in annexure number, Your Lordship. It's in agreement is in annexure number.
Agreement executed between you and the government.
Yes, it's annexure number 3, page 30.
So on the basis of this, you claim that the land belongs to you.
Yes.
This annexure, this is handwritten.
Yes, handwritten type copy is in page number 31. And thereafter, there is one more vital.
Just a minute, not thereafter. Just let us see this first.
Type copy is in page 31.
Okay, who has executed this? Where is your name?
My name is in at the top, Yorkop Gade.
Owner of acre of costly land, do hereby agree to donate the land with horticulture garden to the government at free of. It's free of cost.
Your Lordship, it has a cost, free of cost provided, Your Lordship.
Soap license with the soap license in
Yes.
the year 1977.
Yes.
Soap license was necessary.
Yes, Your Lordship.
Subsidy. Future and what is this facilities be given to me for?
I have donated many acres of coastal land. In fulfillment of this condition.
Now, who signed this?
This is political interpreters, Your Lordship.
Where do we find the name of the political?
Your Lordship, it's Tommy Bazar Nyapek Lombi, PI Tirbin. And copy was served to DC Along, CO Tirbin.
No, this is witness only.
Your Lordship, that was the issue raised by me at the trial court, Your Lordship.
This is only witness.
Yes.
They are, where is the officers who signed on behalf of the government?
That is my case, Your Lordship. Basing on this agreement, they are illegally occupying my land, Your Lordship.
No. What do you mean? Is it not just other way around?
No, Your Lordship, my title suit was for 2 points. They are occupying my illegal. I had enough documents to, if the trial court had allowed me.
See.
Yes.
When I ask you the document, you said that there is no document at all.
Yes.
And this is the first document you are showing me, showing your land.
Yes.
Okay. And this first document, my question, next question
Yes.
is, it appears you are Yorkop Gaddi.
Yes.
Okay. Where is the sign of the other sign of the other party, the government?
These are the political interpreters here sent by the deputy.
This is witness. They are witness. Where is the other party? There used to be 2 party.
Yes.
Okay. First party, second party,
Yes.
and then witness. Where is the second party?
Second parties are these people only, Your Lordship. This public.
How the witness can be second party?
Your Lordship, I am before Your Lordship on a second appeal, Your Lordship. Only the specific substantive question of law.
In the second appeal also,
Yes.
I need some basic information
Yes.
to come into conclusion.
Your Lordship, only my title suit was dismissed on the 2 grounds that I have no cause of action.
Yes, there is no cause of action, it appears.
Your Lordship.
That is why, because you have to satisfy this court first.
Yes.
Thereafter, low point will also come. This is low point only.
Yes.
Fact as well as low point. Because it seems you have no cause of action. Where is the second party? On the basis of which you are claiming, because that's the very core
Yes.
of the matter. Okay, the issues, the first you have to establish that this land belongs to you, and that is belongs to you. Then if your land, this land belongs to you, then everything, whatever comes thereafter, will go in your favor.
Yes, Your Lordship.
That is why first I want to confirm.
Your Lordship, there were PWS evidence also. And even
Forget about the evidence. Forget about the evidence.
Yes.
Evidence comes later on only.
Yes.
So many people will come and so many, they will speak so many things. So many PI also will appear thereafter.
May I take Your Lordship in that
Okay.
case? May I take?
No,
your-
just first let us clarify this.
Yes.
Where is the other party? This is the first document based on which you are claiming that this land belongs to you and there is an agreement with the government.
Yes.
Where is the other party?
And basing on this agreement, they are issuing me work order, Your Lordship. They are admitting
I have
that
no
this
idea.
land
No, I have
is
no
on
idea.
record, Your Lordship. It
See,
is
that
on
comes
oath
later
they have
only.
affirmed
That
before
comes-
the
no.
Lanet Civil Court that they have issued an work order. It is on oath, Your Lordship, before the trial court, Your Lordship. They have admitted, which clarifies, which
Who admitted? Who signed that?
the
Whether
respon-
this person,
respondent number 4.
Tommy Basar, Nyorak Lombi, who had examined?
Yeah, that chance was never given, Your Lordship. At the scratch itself, Your Lordship, at the beginning for having no cause of action, my title suit was dismissed, Your Lordship.
Who was at that point of time? Who was the authority? Who authorized this?
It
Yeah,
was Deputy Commissioner Wesiang District, Your Lordship.
Who was that?
He is the district collector, Your Lordship.
I think it's difficult.
Your Lordship.
Because the court would be needing those basic information. First, you have to establish your ownership. Yes,
My lord, I beg to mention item number 31, my lord.
yes,
My lord, this matter can be fixed on 8th, my lord, Monday.
Mr.
El Kurdu,
El Kurdu.
SPP, SIT.
Special PP, SIT. You are for?
For SIT, my lord.
Correspondent?
Number 1, yes, my lord. I have
Okay,
taken
who is
consent
for the
from,
petitioner?
I have taken consent from the petitioner.
Okay,
Is the-
with the consent of the land council for the petitioner press for distinct matter
8th, my lord, 8th of this month.
on 8th.
Yes, ma'am.
If there is a law, list this matter on 8 accordingly.
Deeply obliged.
So, first of all, you have to satisfy that. Because this court, unless satisfied that, yes, unless satisfied and convinced that, yes, the land belongs to you, it will be difficult to proceed with. The rest will come. So that is a manufactured, whatever may be,
Yes.
it's possible. So that is why the court just want to satisfy. You have to establish first. Okay. So
In that
is there
case,
any other matter also?
Yes, Lordship. Item number 32 is there, Lordship.
32, 30, who is there?
Hearing matter, 32.
32.
Yeah.
Are ready otherwise?
Otherwise ready, my lord, the respondent number 2 will appear through VC, my lord. And it's a very simple matter, my lord. It can be
Okay.
disposed of within 10 minutes, my lord.
Within 10 minutes?
Yes, my lord.
For criminal revision?
Yeah, it's just a procedural lapses, my lord. The opportunity of hearing has not been given before
Okay.
taking cognizance.
Okay, we'll continue at 2 then.
Yes, my lord.
Okay. Yes. Yes.
yes, Your Lordship. Therefore, Your Lordship, basically what I'm trying for is that while admitting this, Your Lordship may revert back it for a proper fair trial at the trial court, Your Lordship. That's all what I'm wanting, Your Lordship. All my ancestral land has been taken, Your Lordship. Now I don't have even an inch of land at Tirbin, Your Lordship. In my written argument, Your Lordship, I have written it in depth. Your Lordship may peruse the written argument and accordingly pass an order.
Let us see just where is the judgment of the trial court?
Yes, it's in page number 42, Your Lordship.
The trial court also observed that I found that there is no signature of the government official, neither any undertaking was executed. So why this is not a? Just a minute, yeah. No cause of action. What is the appellate court's order?
It's in
Okay, judgment.
page number
55.
55.
Where is the substantial question of law? Framed by this court. On page?
It's still on 01/08/2024, Your Lordship.
01?
08/2024. Uh, 08/01 I'm sorry, Your Lordship, 08/01/2024.
Yes, who is for the respondent? Respondent is? Okay, the lane is under the possession of LGBTW. Okay. Yes, what is your submission? Yes. Now, you are admitting that there is an agreement between the government and the petitioner, appellant. Okay, you did not dispute the document, which was not signed by the government. Mhm. So when you come to the bar of limitation, that means admitting that there is a valid document. Yes. That was never signed by the government. Hmm. So, but when you raise this limitation, that means you're admitting that land belongs to him and there is a agreement between the appellant and the government. Hmm. Hmm. Right. Certainly. Where do, page 10. This is the plaint before the district session, additional district session court. Okay. Hmm. 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 This is paragraph 17. This is, I think, no complaint. No, this is not the plaint. Because title suit. Oh, this is judgment. Yes. Hmm. Okay. Just a minute. Mhm. Good. Yes. Where, prayer number A? Okay, okay.
By the executive engineer, Your Lordship. That is not a part of the trial, Your Lordship. It was never exhibited, Your Lordship.
Which document?
Uh, Your Lordship, Annexure 11A, which he annexed in this appeal, Your Lordship.
Page?
Page 70, Your Lordship. The type copy is at 71.
Of the plate? Oh, sorry, of the appeal memo?
Yes, Your Lordship, of the appeal memo, Your Lordship. This letter
Page 17.
was 70, Your Lordship, 70.
So this is not a part of the
Trial, Your Lordship.
trial.
Yes, Your
So
Lordship.
he has annexed here in the
Yes, Your
appeal.
Lordship. And in second,
So that is why I'm saying
yes, Your Lordship, he cannot.
all these constructed documents cannot be.
Yes, Your Lordship.
You should have contested. Okay. So yes.
Even if we presume, Your Lordship, the land was his prior to 77, Your Lordship, then also if we take the time limit, Your Lordship, it's more than 12 years, Your Lordship. It's way beyond the period of limitation, Your Lordship. Which is why, Your Lordship, the trial court has rightly dismissed the title, Your Lordship.
From which date? You said 12 years.
The undertaking date, Your Lordship, 1977.
Undertaking, or undertaking is 16. Or not undertaking.
Yes, 7/3/1977, Your Lordship, page 30 of the
Page 30
of the appeal, Your Lordship. Annexure 3.
This was 77.
7/3/77, Your Lordship. 77, Your Lordship. Even if we calculate the date from
the filing of the title suit, Your Lordship. It's more than 30 years, Your Lordship.
He should have come within how many years?
Within 12 years, Your Lordship.
Well,
Yes, Your Lordship.
there is as per section
3 of the limitation, Your Lordship. And
Part 5, page 31 of Barrett, 32 of Barrett. Section 66 of Part 5.
in Your Lordship, it was only after the work order dated 6/10/2015, Your Lordship, he has initiated the legal notice against the department, Your Lordship. May I take Your Lordship to page number 36 of the appeal, Your Lordship?
page
37, Your Lordship,
what
of
is
the
that?
appeal.
What is this?
This is a work order, Your Lordship,
Hmm.
to the plaintiff itself, to the appellant's father, Your Lordship. Order for work described given below to Sri Yoko Gadi, contracted to be executed as per attached and so and so, Your Lordship. It is dated, Your Lordship, 18/3/2015, Your Lordship. And Your Lordship, the first legal notice was in 6/10/2015.
No, so is there any condition or anywhere mentioned that this work order has been given to the
No, Your Lordship.
appellant?
No, Your Lordship. As per the 1977.
It's just normal work order,
Yes, Your Lordship.
not for any return or
Specific,
no, nowhere mentioned.
no, Your Lordship. No mention, Your Lordship.
It's
Okay,
mentioned, it's mentioned in page 70, Your Lordship.
What is page 70?
This is the position filed by,
No. Here in work order.
No,
Yes.
Your Lordship.
with attaching this work order, they have filed this, stating that as
No,
per serial
no,
number-
I'm asking about the work order. In the work order, any work order, anywhere mentioned that whom this work order was given?
Your Kop Gade.
Your cook.
Yes, your Kop Gade.
And your cook Gadi, according to you, is the owner of the
Yes,
land.
yes. The dispute.
Your cop.
Yeah,
Your cop.
Your Kop.
He's a contractor.
No, he's not a contractor, but a senior citizen of Tirbin Circle.
This was given in the year 2000.
8/3/2015, 18/3/2015, Your Lordship.
And then
And the first legal notice was issued on 6/10/2015, Your Lordship.
16. Okay.
This was in the March.
Had you not given any work order, had this engineer not given any work order, he would have not filed.
Yes, Your Lordship. It was just an afterthought, Your Lordship.
Acha. So this engineer, assistant engineer knew that he was the owner.
Exactly.
Okay, so in the 77,
Yes.
since 77, 80, after 40 years,
Nearly 40 years. Your Lordship.
Yes.
nearly 40 years, now the engineer, this engineer remembers him.
Yes, Your Lordship.
Acha.
That
is interesting.
To clarify, Your Lordship,
Uh-huh.
that agreement, 1977 agreement was a conditional agreement, which says that in near future also,
Okay,
if
so
any kind
so
of
prior to this, there was no any work in the which department?
PWD.
PWD. So
Yes.
for 40 years, nothing was there.
Yes, nothing was that they were verbally saying that we'll provide you the
So when the
contractual work.
first work came up, so he was given this work order.
Yes, in 2015, Your Lordship.
The link is amazing. Okay. By the way, what is this? The appellant is still alive.
Appellant, the earlier title should appellant is alive. The earlier title should the who had died. His son is here, Your Lordship.
Title suit was filed by whom?
Your Kop Gadi, father of Koppa Gadi. Now Koppa Gadi is here before this court.
Okay. Yorkop Gaddi
Yes.
was still alive in the year 2015-16.
Yes, till the first appeal at
Where is the legal notice you said?
legal notice is in page number 73.
So this, okay, anything? Yes, then.
Your Lordship, regarding this work order, it has not been exhibited in the
So
trial.
this was also not exhibited.
No, Your Lordship. The sketch map which he has produced before annexed exhibited, that was this was dismissed by the trial court, Your Lordship, because it was not from the
This is also
revenue
not
department.
a
Your-
trial court document.
Yes, Your Lordship.
Okay. Then
And Your Lordship, the bill which he submitted to the before the CO Basar, at that CO Tirvin, Your Lordship.
what bill?
loss assessment bill of the horticultural products and all. It was exhibited as Exhibit 3 in the studio. This was also discarded by the learned trial court, Your Lordship. Considering all this, Your Lordship, the trial court has rightly dismissed the title suit, Your Lordship.
But the substantial question of law is only two.
Yes, Your Lordship. The answer to the issue number 1 is in positive, Your Lordship. Then the issue number 2 will automatically goes by, Your Lordship.
No, because there is a see, there is a confusion. You say that issue number 1 is
Whether the title suit filed by the plaintiff is barred by limitation of law, Your Lordship.
when we frame this issue,
Yes, Your Lordship.
then it appears to me automatically, assuming that the land belongs to him.
Yes, Your Lordship. But he was
Then if the land is admittedly belongs to him,
yes, Your Lordship.
if it is admitted, then the question comes, limitation runs from which stage?
Yes, exactly.
When the limitation began to run? That question will come. And then probably when you deny, until and unless it is denied,
Yes, Your Lordship.
cause of action not yet arise, limitation will not run because he is still under expectation to get. But in the moment you deny, first we given, if it is assumed
Yes, Your Lordship.
or admitted that the land belongs to him, and then in return of the land
Yes, Your Lordship.
donated to the government,
Yes.
the government has given this work order, and then still he has an expectation that other benefits.
Exactly.
So limitation not yet begun. How it is barred by limitation?
How we can, Your Lordship, then correlate this one, the work order?
That is why I'm saying how this correlate you could accept.
Because in the work order itself, we have never mentioned that this was under the specific.
Now he's saying
It's
now that on what basis you says that it's there's a barred by limitation? On what basis? Barred by limitation means assuming that it was agreed in the year 1977, isn't it?
yes, Your Lordship.
That is why I'm saying there were complications.
But can we reappreciate the facts in the second appeal, Your Lordship? It's my humble question, Your Lordship.
Now, that is why, because you see, the first we have to see on what basis the trial court
Yes,
has rejected. We need to know, this court need to know.
yes, Your Lordship.
Then only this court will be able to decide the substantial question of law on substance, isn't it?
Yes, Your
So I'm on that. So this question, we will be able to decide when it is admitted that the land belongs to him only. Then only this limitation comes. We'll be able to decide on limitation, isn't it? When you say it's barred by limitation,
yes, Your Lordship.
it is already assumed that the land belonged to him and agreement was entered between the government and the appellant in the year 1977, and since 77 he did not approach, And after 30+ years, almost 40 years, he approached. What do you mean by that? It is assumed that the land belonged to him. It is admitted the land belonged to him. And he approached the government for compensation or claiming
Yes,
only after 30 years, 30+ years,
yes, your lordship.
isn't it?
Yes, your lordship.
So that means land belonged to him, isn't it?
Yes, your lordship.
If the land belonged to him,
Yes,
if the agreement is treated to be the correct or the genuine one, then as per the agreement, you have not fulfilled, not yet.
then your lordship, I may like your lordship to this Article 58 of the Limitation Act, sir.
What it says.
It says to obtain any other declaration.
Hmm.
The limitation period is 3 years only, your lordship.
Hmm?
The limitation period is 3 years only, your lordship.
See that if the agreement is treated as a genuine, admitted,
Yes, your lordship.
there is no limitation prescribed there. As and when the government is capable of giving work order, he will be given. Not yet given. He was given only in the year 2015. Okay. And then the another condition is that any other benefit that has not yet been given to him. The moment you refuse to give him the other benefit when he asks, then only a limitation will start running. You have not yet refused it. So,
Then your lordship, I'm sorry, I have to
difficult.
I
So that is why,
have to adjourn, your
see,
lordship.
the go into the detail, I have thought over it.
Yes, your lordship.
Because it's not a simple question of substantial question of law, two substantial question of law framed,
Yes, your lordship.
whether title should be barred, appellant is barred by the limitation.
Yes, your lordship.
This question itself assumes there was an agreement. He's the landowner. There was an agreement between the appellant and the government. And then he should have approached much earlier.
Yes.
After the agreement. 77 agreement entered into in the year 77,
Yes, your lordship.
isn't it?
Yes, your lordship.
Now, how do we decide?
Then your lordship, I have to
Hmm?
yes,
Because
I have
because
to research
we have to
in order-
appreciate
yes, your lordship.
that the Dani trial courts decided so and so and so and so. Thereafter, only I will come, isn't it?
Yes,
This
sir.
court. How do we decide that? How do we appreciate that? How do we discuss that? Need to say here, if we, in order to decide this case, we have to say that land belongs to him. Government and the appellant agree enter agreement. Thereafter, this thing happened. The work order given, isn't it?
Yes, your lordship.
Thereby, the land belong to him only. If the land belong to him, then different question will come. What I'm saying is, if the land belong to him, only one. If the land belong to him,
Yes.
then it seems you have fulfilled one condition, that is by giving work order in the 2015. Then the other condition is that what was the other condition?
Other wanted facilities.
Other wanted facility
Which
you have
means
not yet given.
compensation.
So where the question of limitation comes here? Limitation not yet started. Because you have not yet refused the other wanted condition.
Yes, wanted facilities.
Wanted facilities. Wanted facilities you are yet to give.
Yes.
If the land is assumed, land is admitted that it belongs to him, and you enter with him, then the other facility you have yet to give.
Then your lordship,
May your lordship.
I'm
Your
seeking.
lordship,
Am I correct?
yes, you absolutely.
That is what I'm saying.
Yes, your lordship.
Your lordship, in a civil dispute, despite of receiving of all the petitions and all, they have not even contest the case.
See,
So
you're not
it
contest-
automatically.
and you are sticking on this limitation.
Yes.
Limitation comes only when everything, entire thing assumed to be the correct one. Land belong to him, agreement is correct, land is correct, belong to him. Then, but he should have approached within this, did not approach. But the condition is that if the agreement is treated to be admitted to be the entered into between the petitioner or appellant and the government, then the other condition is yet to be fulfilled.
By
So
not
that's what I'm
contesting,
saying, this is more than what is.
by not contesting the title suit, they have admitted, Your Lordship.
Yeah,
So that's why has been an erroneous application of law by the trial court. That's why, Your Lordship, I'm here. So therefore, Your Lordship, since 2021, this is pending. Your Lordship may pass any order, Your Lordship. We have.
he is yet to prepare. He has just now understood.
Your
The
Lordship, from my
complication.
side, we have two-part heart has also been done.
So that is what I'm saying. That's part that of course that was. Now what do we do?
Just give me a day or two, Your Lordship.
So he need preparation
I
because
can answer that question, Your Lordship.
because this question trial court also
Yes.
have seen, of course not gone through totally, but the appellate court also
Yes.
assuming that although says that he doesn't have, but then didn't say the land doesn't belong to him.
That's the point. That's why I'm here. Otherwise, I have no
Yes, see,
legality to come.
so otherwise, how can I decide on this unless I know the fact?
Yes. By not contesting the title suit itself, they admitted, Your Lordship.
It
In
appears-
civil
it appears-
jurisprudence, Your
It appears.
Yes. And that's why, Your Lordship, on second appeal, if there has been a non-consideration of relevant documents and also erroneous application, then regular appeal, second appeal lies, Your Lordship.
You are right by filing second appeal, but then the decision itself is, according to me, some difficulties we have to deal with properly. Okay,
Yes, Your
you come prepared.
Yes, Your Lordship.
In that case, Your Lordship, fixed date may be given and it may be continued as a part heart, Your Lordship.
I have so many questions here.
Your Lordship, this is a testing case, Your Lordship. That's why I'm
That
also
is why,
trying.
if I decide
Yes.
only on the basis of this substantial question of law,
Yes.
then you see so many things.
Yes, Your Lordship.
Entire Arunachal, everybody will come and claim. Everybody. Itanagar Secretariat will also go. Everybody will come, claiming that it was belong to them, did not pay. And then executive will say that this was at that time the representative of V.V. Giri came and took this land, signed the documents like this. And then one engineer, his favored one engineer will say that some years back, these title members was granted or given a contract work. So use that. So many things will come everywhere, every district.
Your Lordship, there are
That is why it's very difficult.
there are more documents. Had I been had the trial court had not dismissed the title suit at the instance, there are enough documents to substantiate. There are more documents wherein there has been
You will
exchange
have- you will
between respondents.
You will have.
Rightly, Your Lordship, everyone knows. Even
Because your interest. And then because you are interested, and that is why you are finding all these documents. But the government is not interested.
yes, yes.
That is why they need, let them, first of all, let them first know what is it, what is the subject matter. And thereafter, if they want to contest, if they want to admit, and if this goes, because if there is any other scope or any other way, explore it also.
Yes.
Because this is, according to me, this is, although this is in your favor, against him, but not against, not in your favor also, according to me. Both the judgment also.
Yes, sir.
Whole trial was taken over by Justice Hale and Justice Hale, and meanwhile Harinder Kesab was posted. He immediately dismissed this, passed this order, Your Lordship. There was lots of, and this case, Your Lordship, as Your Lordship has rightly pointed. However, Your Lordship, this case is a very genuine and a different case, Your Lordship. So already the title suit pendant was there. So Your Lordship, because this is regular second appeal only, Your Lordship. So even if it is referred back to the lower court will again decide upon whether all those lands and all, they will again refile it because
No, because now you have narrowed down to these two substantial questions.
yes.
You
Only-
have been
only
able to narrow
substantive-
down this.
Only
And then if supposing question, a substantial question of law number 2, whether the plaintiff entitled to compensation, then if this, only this is to be decided, what's the main then? This is assuming, totally assuming that land belongs to you and therefore you are entitled to compensation.
Yes.
Nothing remains. So whether this has been listed as a part hard or
No, Your Lordship.
not
In the
part,
earlier hearing, it was part hard.
no, part hard is
However,
difficult.
yes.
Somebody, some other. Okay. The other court may have different view also.
Yes.
You may take chance also. So keeping it open for you,
Your,
I'll not keep it as a part hard.
Your Lordship, it was hard at the bench of
Yes,
Justice Kardak also, but he was not in a position to hear this, so therefore he has prepared it to be listed in somewhere else. Lordship,
Mr.
R. Raksak.
Raksa, Plan Council for the appellant. Also Mr.
Vairiram.
Ram. Land Council, standing council here.
No, Your Lordship.
No,
Government.
no, okay. Government advocate.
Yes, Your Lordship.
So the land government advocate for the state was, all the state respondent. Who, Mr. Ram, prays for some time to prepare for placing his argument. Prayer aloud, list this matter. After, how much time you require?
After a week, Your Lordship.
Hmm?
After a week, Your Lordship.
After a week, okay.
Obliged.
Deeply obliged.
Item number 32.
Yes.
I'm challenging the order dated 28th of March 2025, whereby the learned Chief Judicial Magistrate Alo, without giving an opportunity of hearing to the accused petitioners, have taken cognizance of offences under sections 323 and 34 of IPC.
You are challenging the order.
Order, pure order, my lord, will find it page number 52. Sorry, 51 onwards, my lord.
Just a minute. Page, impugn order at page
Page 51. my lord.
51.
May I read, my lord?
Just a minute.
Annexure 4.
Yes.
Today, the case is fixed for appearance of the informant. The informant, namely such and such, is present. Upon perusal of the case record, it is found that the IO has filed charge sheet against the accused persons, namely such and such, for offences under section 323/34 IPC. It is to be noted that initially the FIR was registered under section 324/34 IPC. On completion of the investigation, the IO has submitted the charge sheet against the accused persons under section 323/34 IPC, which is a non-cognizable offence. It is now relevant to be noted that when the charge sheet of the IO discloses commission of a non-cognizable offence after investigation, the charge sheet shall be deemed to be a complaint and IO shall be deemed to be a complainant. See explanation to section 2D CRPC. About this, in my humble submission, the provision of law has been wrongly quoted because the charge sheet in this case was filed subsequent to the coming into force of BNSS. Otherwise, the parameteria section would be explanation to 2H of BNSS. Anyway, next paragraph. In the light of the above facts and legal provisions, the instant charge sheet shall be deemed to be a complaint and IO shall be deemed to be the complainant.
Resultantly, the instant case shall be tried as a complaint case. The complainant is not required to be examined under section 200 of CRPC as the public servant is exempted from being examined as per proviso to section 200 of CRPC. Upon perusal of the complaint, this court finds that a prima facie case is made out against the accused persons under section 323/34 IPC. Accordingly, cognizance of the offence is taken on the complaint. This cognizance order, madam.
Initially it was under
324. Well, I'll just give the brief background.
Hmm?
I'll just give the brief
Yes,
background.
initially it was registered against the accused under
324 and 34 IPC. That FIR, my lord, will find it page number.
okay, 324.
Yes.
And now
Now, at the time of filing of charge sheet, it was filed
charge sheet also filed under
323.
okay, charge at the time of filing charge sheet it was 323. That is possible.
Yes, my lord. I'm not interrupting.
Okay.
What I'm saying is, my lord, since the charge sheet was filed subsequent to coming into force of BNSS.
Okay, it has to be BNSS.
Yes, my lord. In terms of the explanation to section 2H of the BNSS, a police report which is filed for commission of non-cognizable offence has to be treated as a complaint. And the police officer who has filed the charge sheet has to be treated as a complainant. Now, chapter 16 of the BNSS deals with the trial of complaint cases. Now, the first proviso to subsection 2 of section 223 provides that no magistrate shall take cognizance of an offence without giving an opportunity of hearing to the accused person at the pre-cognizance stage. Now, in the instant case, my lord, cognizance of the offence under 323 was taken in violation of the explanation, in violation of the first proviso to subsection 2 of section 223. My lord, kindly have 223 for a moment of the BNSS.
No, BNSS.
223, my lord. May I read, my lord? 223, chapter 16. A magistrate having jurisdiction while taking cognizance of an offence on complaint shall examine upon all the complainant and witnesses present, if any, and the substance of such examination shall be reduced to writing and shall be signed by the complainant and the witnesses and also by the magistrate. Now, the first proviso is very important. Provided that no cognizance of an offence shall be taken by the magistrate without giving the accused an opportunity of being heard. Under
This opportunity was not given.
not given. Under the All Act, there was no provision for hearing at a pre-cognizance stage. This has been inserted.
Okay, so in CRPC this was not there.
Not there.
Okay, so this was taken when it was.
My lord, the charge sheet was filed on 30th of January 2025. That date, my lord, can ascertain from page mark as
just-
folder B of the TC.
FIR was filed on
30th of March 2024.
30.
3/2024.
Okay, and then charge sheet file
On 30th of January 2025.
okay, so
Date, my lord, will find it page marked as folder B of the TCR. That date, 30th of January 2025. My lord, will find a page marked as folder B of TCR.
you must have stated in your petition.
Yes, my lord.
Okay, which paragraph?
Paragraph 8. Sorry, paragraph 9.
Okay.
That the petitioner begs to reiterate that the FIR in the instant case was registered on 30/3/2024 and the charge sheet was filed on 30/01/2025.
And two cognizance on 28.
3/2025.
Twenty-eight.
28/3/2025.
Where is FR you said?
Page number 20, my lord.
20, huh?
20.
20.
Down below. Received today at
Okay.
2 hours 1:30 for a case under circumstances.
24. Charge sheet file on.
Charge sheet, my lord.
Where is charge sheet page?
Charge sheet is a page number, my lord. 25.
No, what is this FIR? Another FIR? 24?
That is a cross FIR from the petitioner, sir.
Okay.
But that is not relevant, my lord.
Okay. So where is charge sheet?
Charge sheet, my lord, is at page number 25 almost, my lord. Though the charge sheet is dated 16th of May 2024, but that was filed on 30th of January 2025 before the learned trial court.
Okay.
That is what I have stated in my paragraph 9,
30.
30/03/2025,
Charge sheet.
30/01/2025.
Yes. And then charge sheet file. And then the cognizance.
Infusion order, my lord, page number 51, 28/3/2025.
Okay. It should be section, it should be under section
Cognizance is taken under section 323 and 34 of IPC, my lord.
223. Not 3.
223.
Okay. So
In my humble submission, my lord, this cognizance order is hit by the first proviso 223. Apparently, my lord, the impugned cognizance order has been passed in violation of the statutory mandate. Therefore, I pray that the impugned cognizance order will be set aside and the trial court may be directed to proceed from the pre-cognizance hearing station. Obliged.
yes.
Yes, my lord, there are so many confusion before the trial court because of this BNSS and CRPC, my lord. So now the parts expect was, my lord, the investigation and FIR was filed prior to the coming into force of the new BNSS. But your lordship, the earlier there was a, now it is no more res integra as the division court has already settled the matter.
Yes, yes.
That if investigation,
notified.
yes, investigation if continued after coming into force of the new court, and if charge sheet is filed, then cognizance and other all the consequences will be taken in according to BNSS, my lord.
This is after
Your lordship,
after first July 27.
yes, my lord, we have to understand it because, my lord, here your lordship, the learned court below is in his failed to appreciate, your lordship, the transition part, your lordship. So and for that reason perhaps he failed to issue the notice, my lord, someone. So now your lordship may kindly come to para 16, my lord, where it has been decided by our own division bench, my lord. Para, my lord, they directly come to 19, my lord, wherein your lordship the observation made by the Allahabad High Court was para, my lord, 19.
Sorry, para 19.
Para 19, yes, your lord.
Not 16.
Not 16, my lord. 19. This has been perfectly agreed by the division bench, your lordship. I will come to that. Now, your lordship, para 19.
Yes.
After taking into consideration the decision rendered by the Honorable Supreme Court in Hitendra Vishnu Thakur Supra and Naina Anjana Supra, the division bench of Allahabad High Court held as follows. From the above discussed case, the following legal position is called out. that amended repeal procedure law will be applicable retrospectively unless otherwise provided in the new act itself. Liability or right accrued under the repeal act will not be affected and same will continue as if the repealing act did not come into force. Procedure of investigation, trial, revision and appeal as well as the forum of remedy is a part of procedure law and the same will be applicable retrospectively unless otherwise provided in the new procedure law. Litigant have no vested right in procedure law but has vested right in substantive law with accrued right or liability. The statute which not only change the procedure but also create new right and liability shall be construed to be prospective in nature unless otherwise provided. From the above analysis, it is clear that if any offense is committed prior to the enforcement of new criminal law, then if the FIR is registered after the enforcement of new criminal law, then the same will be registered under the provision of IPC in view of Article 20 of Constitution of India. But the procedure for investigation will be as far as BNSS. Similarly, in case the offense is committed after the enforcement of new criminal law and thereafter the FIR is registered, then the investigation would be considered as per BNSS. However, in case the offense is committed prior to the enforcement of new criminal law, the FIR is also registered prior to the enforcement of new criminal law, then the procedure of investigation would, as per CRPC in view of section 531 subclause 2A of BNSS. Therefore, the procedure of investigation provided by the circular dated so and so of the Police Technical Service System Headquarters UP is absolutely correct. On the basis of the above analysis, this court is also summarizing the law regarding effect of repealing the IPC and CRPC by BNS and BNSS respectively. The same is being mentioned as below. Now you'll have to hear it come. If an FIR is registered on or after 1/7/2024 for the offense committed prior to 1/7/2024, then FIR would be registered under the provision of IPC, but the investigation will continue as per BNSS. Now, subclause 2. In the pending investigation on 1/7/2024, on the date of commencement of new criminal law, investigation will continue as per CRPC till cognizance is taken on police report, and if any direction is made for further investigation by the competent court, then same will continue as per the CRPC. Now, this clause 3 will apply in this case. The cognizance of the pending investigation on or after 1/7/2024. Now, here the charge sheet was filed on January, would be taken as per BNSS. And all the subsequent proceeding, including inquiry, trial, or appeal, would be conducted as per the procedure of BNSS. Section, now you'll see the three is applicable, the cognizance on the pending investigation on or after 1. So here in this case, so far as BNSS is concerned, my lord, the offense was committed prior to the coming into force of the BNSS, but investigation.
The offense was committed
prior to the coming into force of BNSS. Yes, my lord. But, my lord, but the investigation was completed only in the month of
the FIR we do fine.
Sorry, madam.
FIR file.
FIR 33/2024.
33/2024.
33.
Yes, my lord. Yes, my lord. Your lordship will find in page number 21.
Page number 21.
Page number 21, my lord. The FIR.
Page 20.
21, my lord. 21 is the detailed report before the police.
Yes.
Now this is the written one on page number 20, my lord. The lordship will find in 33/2024, March 2024. Now, your lordship, this need to be clarified because your lordship.
Just a minute.
Yes.
Where do you receive information?
Received today at 0200 hours on 33/2024. My below.
This is after BNSS only.
No, prior to BNSS, my lord.
2024.
BNSS come into force on 1/7/2024, my lord. 1/7.
Okay, not 23.
Not 23, my lord. It's 23. Bill was passed on 23, but it was assent was given on 2024, my lord.
1/7/2024.
Yes, my lord.
Okay, that is why.
Yes, my lord.
He was confused.
Yes, lordship. So this need to be, my lord, reflected by this honorable court because here now, your lordship, prior to the coming into the BNSS, FIR was registered, but your lordship will find in clause 3 of the Allahabad High Court judgment, which was agreed by the perfectly agreed by our division bench, that cognizance on the pending investigation on or after 1/7/2024. Here, the charge sheet was filed on 31/2025, my lord. So, meaning thereby, investigation was complete after the commencement of the new court, my lord. The Sanhita, and the cognizance was taken on the January itself. Meaning thereby, my lord, the BNSS should apply in this case. So now, your lordship, this is the actually the paragraph referred by the division bench. Now, your lordship will
Three.
yes, my lord, in paragraph number 19, your lordship will find.
Yes.
Paragraph 19, and in 19, my lord, paragraph 16, my lord, your
Yeah,
lordship will find
63,
14,
63.
15, 16. In para 16, subclause 3 would apply here.
Clause three,
The
yes.
cognizance on the pending investigation on or after 1/7/2024 would be taken as per BNSS. And all the subsequent proceeding, including inquiry, trial, or appeal, would be conducted as per BNSS.
Yes.
Now, it is clear, my lord, that BNSS would apply.
Yes. In this.
Now, your 20, my lord, here is the observation of our division bench. We are in perfect agreement with the view expressed by the division bench of Allahabad High Court in Deepu Supra. Now, this has been upheld by taken by our own bench, my lord, division bench. So, in this case, clause 3 will apply. Now, so far as, my lord, the applicability of BNSS is concerned, now it's settled. Now, the second part is, my lord, here initially the offense, one of the offense was cognizable one, my lord. So for that, the investigation has been conducted, investigation has been carried out, because if the offense is cognizable, then investigation authority has to investigate the matter as per section 154 of the CRPC, my lord. So now after culmination of the investigation, my lord, the accused has been charge sheeted under section 323 and 34 of the IPC.
Yes.
This section is non-cognizable, my lord. So now when it becomes non-cognizable, the definition your lordship will find in BNSS, section 2H will come, my lord. Section 2H of BNSS, my lord.
Yes. Yes. Just a minute. Not 2D of CRPC.
No, my lord. My lord, 2H, because now the BNSS will come, my lord.
Yes.
So now we have to refer the BNSS. 2H, my lord.
Complaint.
2 is the
Yes.
definition, H is the definition of the complaint,
Yes.
and there the explanation will come. Now I will read, my lord. The complaint means any allegation made orally or in writing to a magistrate with a view to his taking action under the Sanhita that some person, whether known or unknown, has committed an offense but does not include a police report. Now, police report is absolutely excluded. Now, explanation, my lord, here. A report made by a police officer in a case which disclosed after investigation the commission of a non-cognizable offense shall be deemed to be a complaint. And the police officer by whom such report is made shall be deemed to be a complainant. Now, the police officer is become de facto complainant in this case.
Yes.
So, when your lordship, the same corresponding section of the section 200 is 223, my lord. There again, one provides it provides that the public servant or the government official is not required, their statement is not required to be recorded for the purpose of taking cognizance. Now, before that, even for the purpose of taking cognizance, the new provision which has been inserted is the accused must be given an opportunity before taking cognizance. So that part is missing here in this case.
Yeah.
So that is why, your lordship, I just dragging it from the applicability of the BNSS, because we have to understand,
Right.
and most probably, your lordship, the learned court below has misunderstood the applicability of the BNSS or the CRPC, my lord.
Yes.
So here in this case, my lord, the impugn order clearly shows that the learned trial court failed to appreciate the requirement or the provision of section 223, wherein before taking cognizance, an accused must be afforded an opportunity. So without doing so, he has taken cognizance and issued summon, which has been stated by this honorable court, and your lordship fairly submitting which is in fact need to be interfered with by remanding this matter back, your lordship.
Okay. So I'll pass order.
Is for the complainant.
Private respondent, anything?
Nothing, Lord.
Okay.
I concede, Lord.
Okay.
Just one clarification. The FIR is 2016/2024, but from page marked as folder B of PCR, 30/01/2025 can be accepted.
30?
Set A for which the FIR was filed is that page marked as folder B of the PCR. Folder B of the TCR. my lord. From that page, we can ascertain that the FIR was filed on 30th of January 2025.
Not March.
Oh, sorry, the charge sheet, sorry.
It's 2025, charge sheet only.
Charge sheet. Sorry.
Yes, 30 January, that is clear. Okay. Had Mr. R. L. Tungon, Land Council for the petitioner. I've also heard Mr. P. Edgar, Land Additional PP for the state respondent, and Mr. J. Jin for private respondent number 2, 3, and 4. Okay. 2, 3, 4, and 5. Okay. I'll dictate. Okay. But I'll pass order.
Deeply obliged.
We'll remand it back.
Yes, madam.
Okay. With the direction
Yes, madam.
to proceed with the matter from the pre-cognizance stage.
Yes, my lord.
Okay.
Within 2 months, madam.
Within 2 months.
Yes, madam, because there is an election and other.
Okay. 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 Yes.
Finish, Lordship.
Okay.